the interlocutory application is allowed, subject to payment of cost of ₹5,000 by the applicant to the respondent within a period of 15 days. On deposit of such costs, the connected review application may be registered and listed for admission column thereafter.
Please, Your Lordship. Lordship, item number 30, consent the.
Item number
33, Lordship.
Yes.
Paying for an accommodation for today, Lordship.
33.
30, Lordship.
It's wrong, my lord, there, right? So it may be fixed on 28, my lord. 28.
No, fixing will be difficult. We will
No,
give.
additional, my lord. Yeah, additional.
Okay. Heard Mr. J.N. Sahewala, Senior Counsel for the appellant. Also heard Ms. M. Nirola, Learned Counsel for respondent number 2 and 3. 2 and 3. For Learned Counsel for the respondent who prays for an adjournment on what ground?
A.K. Gupta has.
On the ground of personal difficulty of the conducting counsel for the respondent. The prayer is not opposed to by the counsel for the appellant. Hence, the prayer is allowed. Let this matter be listed on 28th of June. May.
Obliged.
May I please, Your Lordship? Item number 16, my lord. Well,
1-6.
16, my lord. I would make it free, my lord, if it reaches, my lord. Otherwise, Lordship may take up this matter at 2, because what has happened, my lord, this matter has to be remanded back. It's a order by the
No. 2. You have to wait.
My lord.
It may fail. Who is for the other side?
My lord.
It has to be remanded because our High Court has recently passed a judgment that the single bench of the
Yes.
tribunal cannot decide the
Take up
matter.
that.
So
Okay.
no,
That's
Okay.
that's the only thing to be decided. my lord.
We'll take it up at 2.
it will take 1 minute.
Okay, we'll take it up 2.
Well, wait for listing of a MSc appeal, Lordship, it was lastly listing on 9/9/2024. Already, notice has been served to the respondents.
In which column? Orders column?
Orders column, right?
Next
Any
week.
day, any day.
No fixed date. Next week on a date to be fixed by registry. Next week.
Apply.
Ma'am, did your Lordship, with consent of the respondent, I beg to mention item number 22, Lordship. Conducting counsel of the parties out of station. And the adjourn for 1 week, Lordship.
And Mr. P. Sharma, Learned Counsel for the appellant who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the respondent. Personal difficult counsel for the appellant. He submits that he has informed Learned Counsel for the respondent regarding his prayer for adjournment, who does not have any objection to same. Hence, the prayer is allowed. Let the matter be listed after 2 weeks on a date to be fixed. No. After 4 weeks. No, after 2 weeks on a date to be fixed by registry.
May I please, Your Lordship? My lord, I'm praying for a listing of a FAO, my lord. It was last listed on 21.
Which column?
Orders column,
When do you want?
Monday, man.
Okay.
Mention item number 8.
Yes. What is your prayer?
English counsel is for some of his personal reasons.
For? You are for? You have informed the appellant side. Heard Miss, what is your name? M. Gogoi. learned counsel for the respondent who prays for an adjournment. Also, Mr. R. Karim, learned counsel for the appellant who does not oppose the prayer, hence the prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
Praying for listing of one MSc appeal for admission.
After a week on a date to be fixed by registry.
It is your worship, I beg to mention item number 5.
Five.
Consent, the other side.
Yes, you are for?
What do you feel?
What is your name?
DB Gauhati on behalf of.
Heard Miss D.B. Gauhati, learned counsel appearing on behalf of Mr. H. Burma, learned counsel for the appellant who prays for an adjournment. On what ground? On the ground of personal difficulty for the conducting counsel. Also, Mr. A.S. Basar, learned counsel for the respondent who does not have any objection to the said prayer. Hence, the prayer is allowed. Let this matter be listed after 3 weeks.
Lordship, can this matter be fixed on the last week of June as my senior is having some
After 4 weeks on a date to be fixed by registry.
Keep the update.
Should I to mention for listing an MSc appeal?
Next week.
Lordship, I should not take the concern of the other side in this item. However, Lordship, I beg to mention item number 17, 18, 19, 23, and 35. Lordship, when the matter reaches, I will, because my senior has some personal difficulties.
Item number?
17 and 18, 19, 23. 35.
You remain there if matter reaches 17, 18, 19,
23 and 35.
23, and 39. Okay. We are not passing any order now. Let us see whether it reaches or not.
Lordship, in item number 19, the other side is there. Lordship.
Item number 19, heard Mr. S.P. Sharma, learned counsel for the appellant who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the appellant. Also, Mr. S. Datta,
Respondent 6, 7, and 9.
learned counsel for respondent number 6, 7,
And 9.
and 9,
Lordship, in 17, 18 also other side is.
who does not have any objection to the said prayer. Hence, the prayer is allowed. Let this matter be listed after 3 weeks on a date to be fixed by registry. Next, 17, 18. 17, 18, same order. What is your name? In place of S. Datta, A.S. Molla. Okay.
Orders, item number 1.
Apologies, my lord, for the interruption. There is one more mentioning, my lord, in respect to item number 24, my lord.
Item number?
24, first item.
What is the prayer?
My lord, can it be taken upon some other day? I have obtained the consent from the other side.
Heard Mr. D. Rathi, learned counsel for the 24.
Yes, come to.
Learned counsel for the appellant who prays for an adjournment on the ground of personal difficulty of the conducting counsel on his personal difficulty. Also, he submits that he has informed learned counsel for the respondent regarding his prayer for adjournment, who does not have any objection to the same. Hence, the prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
Much obliged. I beg to mention, item number 2.
Item number 2. What is that? Item number 2, wait. We'll take it up. No need for mentioning. Yes, Mr. Bas.
Item number 1.
Orders, item number.
Okay. Wait. Yes,
I beg your pardon, Lordship, in this particular case, we have taken steps on respondent number 1 and 2 by Dasmi, but I could not serve because you could not locate the person. Earlier, Lordship, a restart post and AT has been sent, that was to return. Lordship, in this particular case, respondent number 3, United Insurance Company, my claim has appeared. And 1 and 2 has not contested the case before the tribunal. My case was my husband died. My claim was dismissed on the ground that I have not included.
dismiss.
My case was dismissed by the tribunal on the ground that I have not included another vehicle which was involved in the accident. Because tortfeasor has the right to claim a compensation against any one of the tortfeasor. That is the established principle. That wrong has been committed by the tribunal. And admittedly, 1 and 2 has not contested the case. Lordship will find the appeal memo. They have not appeared. The ex parte order has been passed. Lordship can see the appeal memo. Lordship can see the appeal memo, page 7.
No, I'm
Only to show that they have not contested the case. Order 41, rule 14.
14.
14.4. May I read? Lordship?
Yes.
Notwithstanding anything contrary contained in the sub-rule 1, it shall not be necessary to serve notice to any proceeding incidental to an appeal. Incident to an appeal on a respondent other than the person implicated for the first time in the appellate court unless he has appeared and filed address for service in the court of first instance or has application in the appeared in the appeal. He has not appeared in the tribunal itself. The appeal again will try to serve him copy also. And my friend has no objection for condonation of delay because it is just cause. Also.
But in appeal, you have to issue.
We will take the statements after admission.
Heard Mr. S.K. Goswami, learned counsel for the applicant. Also heard Mr. K.K. Bhatto, learned counsel for respondent number 3. On perusal of the office note, it appears that learned counsel for the applicant submits that in spite of attempt being made by the applicant, notices could not be served upon respondent number 1 and 2 by dusty mode as their addresses are. Why notices could not be served?
Lordship, no, we collect the address from the claim from the police report form 54. In the form 54 address, we try to serve by a restart post with AD. That also could not serve. By a dusty service, also we try to locate the person. We could not.
Last line only. He submits that respondent number 1 and 2 did not appear before the tribunal also, and the inquiry proceeded ex parte against them thereto. He therefore submits that in the instant interlocutory application, the notices to the said respondents may be waived under Order 41, Rule 14, within bracket 4 of the Code of Civil Procedure 1908. The prayer is not objected to by the learned counsel for respondent number 3. I have perused the records which indicates that the inquiry proceeded ex parte against the aforesaid respondents before the Motor Accident Claims Tribunal number 3 Kamrup Metro. Hence, notice to them in this interlocutory application is hereby waived. Stop. This interlocutory application under Section 5 of the Limitation Act 1963 has been filed by the applicants in connection with applicants for with a prayer for condonation of delay of 217 days in preferring the connected appeal, whereby judgment and award dated. It was dismissed, whereby judgment dated 7/5/2019 passed by the Motor Accident Claims Tribunal number 3, Kamrup Metro in MEC case number 1557/2015 has been impugned. Learned counsel for the applicant submits that the applicants have stated the reasons for delay in paragraph number 3 of the instant interlocutory application. Mr. K.K. Bhatto, learned counsel for the respondent number 3, submits that considering the grounds stated by the applicants in the instant interlocutory application, he does not have any objection to the prayer for condonation of delay made by the present applicants. Stop. I have gone through the records and have considered the submissions made by learned counsel for both sides. It appears that reasons shown in paragraph number 3 of the 3 and 5 of the instant interlocutory application may be regarded as sufficient cause which prevented the present applicant in filing the connected appeal within the prescribed period of limitation. Stop. Accordingly, the delay of 217 days in preferring the connected appeal is hereby condoned and this interlocutory application is allowed. The registry is directed to register the connected appeal and list the same for admission after a week on a date to be fixed by it.
The name of the KK Bhatto looks for
Name of Mr. K.K. Bhatto may be reflected as engaged counsel for respondent number 3 in the cause list henceforth.
Item number 2.
Yes.
Follow it and see your personal.
Oh, I'm not hearing anything. You have to be a little louder. You are praying for adjournment. What is your prayer? For
Personal.
heard, Mr. What is your name?
A.W. Mundal. We have
A.W.
A.W. Mundal.
A.W. Mundal appearing on behalf of Mr. M.U. Mundal, learned counsel for the appellant. Also heard Mr. S.P. Sharma,
Respond number 1, Lord.
learned counsel for respondent number 1. On perusal of the office note dated 19/5/2026, it appears that notice to respondent number 3 has been duly served on him. Hence, duly served on him. Stop. However, it appears that notice issued to respondent number 2 has been received back with a postal endorsement within bracket insufficient address. In view of the above, the appellant is directed to take fresh steps for issuance of notice upon respondent number 2 after finding out correct address, stop within 15 days from the date of this order by speed post as well as by usual mode. Returnable on 24th June. No, July due. July. July after vacation. 15 July. 14 July.
15. Item number 3.
Wait, the Lordship. Lordship, this matter is ready regarding service and reports.
Ready?
The respondent claimant, there is an order for early hearing. Yes, because what is the claimant husband died. I have filed a petition for early hearing and discharge allowed. So that will be for hearing.
When do you want?
Next week. 28.
28, if we list, it will not reach. We can list it.
Then second room. Hearing date.
Heard Miss M. Saikya, Learned Counsel for the appellant. Also heard Mr. K. Sharma, Learned Counsel for the claimant respondent. It is submitted at bar. It appears from record that this appeal is ready for hearing. It also appears that there is an application filed by the respondent claimant for expeditious hearing. You file an IA?
I was disposed there, I was state.
No, early hearing application.
Yes.
Or early hearing. Let the okay, so 1809. Not this one. Yes. Okay. Let this matter be listed on 2nd of June for hearing.
My name is not shown in the court.
Name of Mr. K. Sharma be reflected as engaged counsel for respondents claimant in the cause list henceforth.
Item number 4.
Maybe just. In this case, in persons to order dated 30/4/2026, I have taken step post the service upon the respondent two. And it is duly received by the general manager NF Railway. I have filed affidavit. I have take, but it is not paid. Post the service affidavit is not paid.
You have filed a
18/5 I have filed.
affidavit showing service of notice. On whom you have served.
Convert 2 years. General manager NF.
No, along with your affidavit, have you annexed the copy of notice? No, acknowledging the receipt of the notice. Where?
No affidavit here.
Affidavit submitted before the court.
But it is not tagged here, right? It is my copy here, right? That I
No,
mean,
in your copy.
last.
Okay.
It's a delay, your lordship, in 17 49 days delay. Favoring the connected. Delay I have taken.
You submit a copy of notice also, along with your affidavit.
I already served your lordship. Notice I have. It's not recorded. Okay. In my website.
When have you filed affidavit?
15 14 I have taken steps. Notice served on 14/5, I have taken step on 18/5.
It is not there in the court.
Not now. Honda is showing it is, that it is not there.
We'll direct the registry to tag it and thereafter we'll pass orders. Heard Mr. S. Islam, learned counsel for the applicant. Also heard Mr. S. Datta,
For respondent one.
learned counsel for respondent number 1. Learned counsel for the applicant submits that the notice to respondent number 2 has been served by Dusty Mode and the applicant has also filed an affidavit on in compliance thereto. However, the said affidavit is not available in the record. The registry is directed to place the affidavit in compliance filed by the applicant with record on next week at the date on 1st June. You check, go through the record. এতো রিটার্ন করে দেব।
Item number 6.
Please, your lordship, LCR has been received. And services complete.
Services complete. Heard Miss M. Saika, learned counsel for the appellant. On perusal of the office note dated 18/5/2026, it appears that the records of MSC case number 2393/19 has already been received. The service on respondents have already been completed earlier. This appeal is accordingly ready for hearing. Let this appeal be listed for hearing after 4 weeks on a date to be fixed by the registry.
Item 9.
So this may be everything yes because this one number 3 and 2. One and 3 has appeared.
Heard Mr. K.K. Bhatta, learned counsel for the appellant. On perusal of the office note dated 5/5/2026, it appears that the records of the MEC case number 517/2018 have been received. However, service report in respect of respondent number 1 and 4 is
Yes, it appeared, but because by mistake it was written in the office notes. I have taken step on respondent number 3 and 4.
3 and 4 are awaited. The registry shall place the postal track consignment report of notices sent to respondent number 3 and 4 by speed post before this court on the next date fixed. Let this matter be listed again. 12th of June.
Attach 7.
And please, your lordship, my lord, there is a condemnation petition, my lord, 211 days. Earlier, I have taken steps, 2 steps, my lord, by Talabana and by speed post, my lord. Last time I have taken the speed post on 7th April.
But there is no indication. You have taken steps by speed post. Okay. Third, Miss B.R.A. Sultana, Learned Counsel for, yes, it is there, not necessary. B.R.A. Sultana, Learned Counsel for the appellant. On perusal of the office note dated 18/5/2026, it appears that the service report in respect of the respondent is awaited. The registry is directed to place the postal track consignment report of notices sent to the sole respondent by speed post before this court on the next date fixed. Let this matter be listed again.
24 June.
24 June.
Item number 10.
May I please, your lordship, as per office note dated 18/5/2026, services in respect of respondent number 1 is completed.
How many respondents are there?
Respondent number 3 respondent are there.
2 and 3?
2 and 3 was completed last time on 7/5/2026.
Okay. Third, Mr. N. Upadhyay,
PV Kapoti.
PV,
Kapoti.
PV Kakoti, Learned Counsel for the applicant. On perusal of the office note dated 18/5/2026, it appears that notice issued to respondent number 1 by speed post has been duly served on him. The service of notice on all the respondents is complete. How many days delay?
70 days.
Stop. This interlocutory application has been filed by the applicants under Section 5 of the Limitation Act 1963, praying for condonation of delay of, where have you mentioned? A delay of 17 days in preferring the connected regular first appeal, whereby the judgment and decree dated 18/11/2025 passed by the Court of Learned Civil Judge Senior Division, Senior Division number Which court passed the order? In money suit number 1 of 2024 has been impugned.
Several wills, Abingdon,
Kamrup. Okay.
Abingdon.
Kamrup Amingam. Where have you mentioned the reasons for delay?
Lordship, delay has been mentioned in para number 2, Lordship.
Why delay was?
First reason is that there was some delay in
The
applying the certified copy.
learned counsel for the applicant has stated the cause of delay in paragraph number 2 of the instant interlocutory application. Stop. After going through the same, this court is of opinion that same may be considered as sufficient cause which prevented the applicant in preferring the connected appeal within the prescribed period of limitation. Accordingly, the delay of 17 days in preferring the connected appeal is hereby condoned and this interlocutory application is allowed. Registry is directed to register the connected regular first appeal and list the same for admission after a week on a date to be fixed by it.
Supplementary item 31.
May it please your Lordship. My lord, the matter may be fixed for hearing.
Heard Mr. D. Rathi, learned counsel for the appellant. On perusal of the record, on perusal, it appears that this appeal is ready for hearing. Let this appeal be listed for hearing after 4 weeks. On a
If any date can be,
date will be it will go to September.
in August, my lord, if any date can be.
August we don't have dates.
After 2 weeks.
After 4 weeks on a date to be fixed by registry.
Item 32.
May I please, your Lordship. Herein, LCR was called for, your Lordship, but it has not been, it has not been received.
Not yet received.
Not yet.
Why?
But
It has been received by ICE. LCR is. Heard Mr. A.M. Khan, learned.
herein the issue is very simple, your Lordship. that-
No, we will not go into issue now, whether service is complete or not.
I think in respect of respondent number 4, it has not been completed.
So first, let
So
the,
what's other, your Lordship? Okay.
who is for?
4 is the divisional manager.
Insurance,
SBI General Insurance Company.
insurance company, you take steps. You have not taken steps.
Step has already been taken.
Oh, it has been delivered. Divisional manager.
SBI General Insurance.
SBI General Insurance. Okay. Heard Mr. A.M. Khan, learned counsel for the appellant. Also heard Mr. K.K. Bhatta, appearing for respondent number 1 and 2 also.
Yes.
One and two also. 1 and 2. On perusal of the office note dated 25/2026, it appears that the notice issued to respondent number 4 by speed post has been duly served on the said respondent. It also appears that the records of MAC case number 368/2022 has also been received. This matter is therefore ready for hearing. Let this matter be listed for hearing after 4 weeks on a date to be fixed by registry.
Possibly, your lordship, date will be fixed, your lordship.
Not possible.
I have no problem, but only I am seeking here.
Let registry do its work.
Okay.
Item 33.
Wait, please, your lordship. Lordship, as per office note, respondent 1 is being represented and the service on respondent 2 has been completed.
How many respondents are there?
There were 2.
Heard, Mr. What is your name?
R. Ghosh.
R. Ghosh, learned counsel for the appellant. Also heard Mr. S.P. Sharma, learned counsel for respondent number 1. On perusal of office note dated 25/2026, it appears that notice issued to respondent number 2 has been duly served. It also appears that the records of MAC case number 70/2019 have been received from concerned Motor Accident Claims Tribunal. This appeal is therefore ready for hearing. List the same for hearing after 4 weeks on a date to be fixed by.
Item 34.
Maybe your lordship, this I has been filed for releasing of the respondent number 1 to 3, your lordship. That is the claimant. That the insurance company, the appellant has deposited the 50% awarded amount as per direction of his lordship. And we filed this lordship for releasing the amount because due to hardship of the.
Any objection?
Side. This that the respondent number 4 is the mother of the deceased. She has passed away as well, and they have implicated the other legal aids. Let's say we mentioned in our paragraph number 5, lordship, the respondent number 4, lordship, the mother of the deceased person. He was expert after passing the judgment, lordship, and we annexed the lordship death certificate and next of kin certificate, lordship. Already other legal.
You have deposited 50%.
Yes.
Okay, let them. Heard Mr.
D.K. Kolita.
D.K. Kolita, learned counsel for the applicants / claimant. Also heard Mr. S. Sharma, learned counsel for the insurance company / appellant. This interlocutory application has been filed by the applicant / claimants for directing the registry to disburse the 50% of the awarded amount deposited by the insurance company before the registry in pursuant to the order dated 27/8/2025 passed in IA number 2783/2025. The insurance company does not have any objection to same. The prayer is therefore allowed. The registry is directed to disburse the 50% of the awarded amount which has been deposited by the insurance company before it in pursuant to the order dated 27/8/2025 passed in IS civil number 2783/2025 to the present applicants / claimants after proper verification.
2 and 3 are minors. They were situated in the FI.
Who is one?
One is the wife of the deceased person, mother of the respondent number 2 and 3 represent the lordship.
As respondent, as the applicant number
2 and 3 lordship.
2 and 3
Yes, that's- Oh,
are minors.
yes, yes.
The registry shall disburse the said amount to respondent number to the applicant number 1, Srimati Sumit Teranpi, who is the mother of the minor respondents. This interlocutory application is accordingly disposed of.
Lordship, another lecture submission is there, Lordship. Respondent number 4, name is strike out, Lordship, from the appeal, Lordship. Respondent number 4, Lordship. Because we have made clear and already we have annexed that.
Who is the legal heir of respondent?
Legal is in these 3 legal year is the legal year, Lordship, the legal year, Lordship. Respondent number 1, 2, 3 is the legal year of respondent number 4, Lordship. Already next of kin certificate is also there, Lordship, in my IA application, Lordship. There is the annexation number 2 and 3, Lordship.
No, in appeal likhibo. In appeal, heard Mr. S. Sharma, learned counsel for the appellant, also heard Mr. D. K. Kolita, appearing for respondent number
1, 2, 3.
1, 2, 3. To 3.
Yes, Lord.
He submits that respondent number 4 has expired when
On 15/8/2025, Lordship.
15/8/2025, and the respondent number 1, 2, and 3 are the legal heirs of the said respondents, and therefore there is no necessity of substituting the legal heirs of respondent number 4. It also appears from office note dated 12/3/2026 that notice issued to respondent number 5 has returned after due service. However, in respect of respondent number 6, 7, and 8, the service report is still awaited. Who are these?
So the Uno,
6, 7, and 8 service report?
driver,
You
But I
take
don't-
phrase. What will you do?
they have not contested the case in the trial court. There's no record of respondent number 8 even in the judgment.
Why have you made them party?
They are a party, but they are not represented and nothing has been shown.
Okay, we'll await service report in respect of the aforesaid respondent. Let this matter be listed after 2 weeks.
So, but that may be fixed.
Hmm?
Lordship, in this another connected appeal, Lordship 380 from 2025, that was also mentioned on, that was also fixed on to the Lordship, but that matter is not listed on to the Lordship.
Let this matter be listed after 2 weeks, along with
384 of the
MEC appeal number 384 of
25, Lordship.
2025.
Yes, Lordship.
Okay.
Lordship, for that is also I have filed Lordship, finally, that may be fixed for Lordship. Because in this also money has been deposited.
After 2 weeks. After 2 weeks at the date, 12 June.
12, sir. Master Lordship.
Clearing daily list item 11.
Lord, it is a pattern matter, Lordship heard it earlier. On the earlier date of hearing, Lordship.
Yes. Yes.
My first submission was that, Lordship, the plain disclosure that Kusumo
अगर नोटिंग सासेनिक
and you notice
Yes, you give some gist of what is the case.
Lordship, the respondent is a lady, Lordship, filed a suit for rejectment under the provisions of the Rent Control Act. So that suit was on the ground of defaulter and bona fide requirement.
Decreed.
Then the present appellant petitioner preferred title appeal, which was upheld the judgment of the trial. Then this revision has been filed. The earlier date of hearing, Lordship, I am the tenant.
Tenant. Decrees against you.
Yes.
Okay.
So,
Yes.
on the earlier occasion, hearing, Lordship, have submitted that the suit itself is not maintainable. As because your Lordship may please to peruse the plain, page 27. Page 27. Lordship got it.
Yes.
Your Lordship will see the MS Kishorilal Vijay Kumari, Hindu undivided family represented by Srimati Kusum Moore as Karta, your Lordship. And the plaintiff number 2 is herself Srimati Kusum Moore. They are the plaintiffs only, your Honor. And as per the uncodified law of the Hindu undivided family concept law, a female cannot act as a karta. So that's why I had submitted that the suit itself is not maintainable.
Female cannot be a karta.
Karta, I have submitted Supreme Court decision, Lordship, on the last occasion. That citation is Lordship 2016. Sorry, 2015, 16 SCC Lordship, page 46. That judgment is in the file.
I got citation will report. Nothing is there in file.
And
No, where is the judgment, impugned judgment?
Impugned judgment, Lordship, is at page. Page 87.
87. In the appeal also you took this plea.
Yes, sir. Suit is not maintainable, that's believable.
How the appellate court dealt with the same?
Nothing. No penalty. Both the courts below did not give any penalty. Page 87.
In this judgment, which para? Para 18 and 20.
Yes. 18 and 20. I have written the para number. Para 18, Lordship. The apex court held that while there can be no doubt that a Hindu widow is not a co-parsoner, not co-parsoner in the HUF of her husband, and therefore cannot act as karta of the HUF after the death of her husband. The two expressions, that is the karta and manager, may be understood to be not synonymous, and the expression manager may be understood as describe a role. The note distinct from that of the karta. Hypothetically, we may take the case of HUF where the male adult co-parsoner has died and there is no male co-parsoner surviving, or as in the facts of the present case where the sole male co-parsoner respondent plaintiff Ashok Vidyarthi is a minor. In such a situation, obviously the HUF does not comes to an end. The mother of the male co-parsoner can act as the legal guardian of the minor and also look after the role as the karta in her capacity as his minor's legal guardian. This is and para.
So your contention was that Kusum Moore, being a female, cannot represent the HUF as its karta.
Because she is also widow. Earlier there was a HUF lordship which was a karta was her husband. After his death lordship, she claimed herself as the karta of the HUF. So after death of the husband, he left behind a son. He is not a party to the suit lordship, and only the son could have been designated as the karta of the HUF. So suit itself is not maintainable.
Where you took this plea? In the written statement.
The WS have taken the plea that the suit is not maintainable.
Any issue was framed?
No, no issue was. But this was argued. But there is no finding by both the courts. And Lordship, may we please to come to the same judgment, Lordship, para 20, from the bottom line, Lordship, 1, 2, 7, line 7 from the bottom of para 20.
No, you raised this plea before the appellate court also in your memo of appeal that you took this plea in your written statement, but no issue was framed.
That was taken in the WS, also it is taken, Lordship.
No, I have understood. In WS, you have taken plea. No issue was framed. Then you preferred an appeal. In the memo of appeal, whether you took any ground that you took this plea.
Question of law, Lord. This is a pure question of law.
No, but that plea was not taken.
That plea was taken, but specifically it was not made.
Okay.
Plea was taken.
No,
Why-
grounds were, the appellate court did not address this issue because you have not mentioned it in your memo of appeal.
In the memo appeal, it was mentioned, Lordship, that the suit is not maintainable, and verbal argument was done that a lady cannot, widow lady cannot act as a creditor.
Okay.
And this is a pure question of law, Lordship. Even if a plea is not taken, then it was the duty of the learned.
No, whether it was pointed out to the appellate court.
It was pointed out, and Lordship, the line 7 from the bottom of para 20, and therefore consistent with the legal position which recognizes a Hindu widow acting as the manager of the accused in her capacity as the guardian of the sole surviving minor male co-partner. Such a role necessarily has to be distinguished from the that of a kata, which position the Hindu widow cannot assume by virtue of her disentitlement to be a co-partner of the HUF or of her husband. The position remained unaltered even after the amendment of the Hindu Succession Act in 2005. Because Lordship, in the amendment of the Hindu Succession Act 2005, only daughters were treated as co-partner in case of the Litakshara School of Hindu law of HUF law. The wife was not taken, Your Lordship, only daughters.
Section 6, section Hindu Succession Act. Okay, continue.
Now, Your Lordship, please to consider that this lady Lordship who claimed herself as the Kata has a son. And at the time of filing the suit, son was a major, not minor. Son was major, Your Lordship. And he was never implemented as a Kata of the HUF or as a co-partner of the HUF, Your Lordship. And in the evidence of the surprising thing is this, Lordship, the plaintiff number 2, the widow who claimed herself to be the Kata, did not enter the witness. No evidence was given from her side.
Okay.
And this law is well settled, Your Lordship will recollect the judgment of the Express Court, Vidyadhar Rao case, Lordship, where it was held that if the citation is Lordship, I'm placing that. The judgment is Lordship 1999, 3 SCC, page 573, Vidyadhar versus Manik Rao. So Lordship, please to come to para 15.
Para 15.
Para 15, Lordship, from the bottom of the para 15, line 4. Line 4, Lordship, from the bottom. If a party absent from entering the witness box, it would give rise to an inference adverse against him. Similarly, a division bench of the Punjab and Haryana High Court in so and so drew a presumption under section 114 of the Evidence Act against a party who did not enter into the witness box. So, Your Honor, the plaintiff did not enter into the witness box, did not file any evidence on affidavit. Evidence on affidavit of PW was filed by her son, who is not a party to the suit.
In this case, it is not a case that she did not adduce any evidence. She adduced evidence not of herself, but of her son.
Who is not a party to this suit, Your Lordship. His name has also not been shown in the plate as the co-person.
So what is your submission?
Submission is this, Lordship, the plaintiff who instituted this suit, that is HUF as well as the lady who claimed herself to be the cutter, did not examine herself, Lordship. And I have cited the judgment of the Vidyadhar case, Lordship. And on the same point, there is another judgment of the apex court, Your Lordship, that is 2010, 10 SCC, page 512, Mankour versus Hartar Singh, para 14. This is 2010 10 SCC 5112 Mankour versus Hartar Singh, para 14. There your Lordship will find in para 9. Para 9. And this judgment is also based on that ratio of Vidyadhar case, Lordship.
Yes.
Para 9, Your Lordship, just above para 10, you'll 1, 2, 3, 4, 5 lines above, Your Lordship. In Vidyadhar, Lordship, got it?
Yes.
Just above para 10, there is a part of para 9, Lordship, line 5, from the bottom of partner.
Yes.
Here, apex court held that in Vidyadhar Manik Rao, 1993 SCC 573, the court reiterated the following well-recognized legal position, where a party to the suit does not appear in the witness box and state how his own case on oath and does not offer himself to be the cross-examined by the other side, a presumption would arise that the case set up by him is not correct. So exactly the case in the present question, in the present division petition is same, Lordship. The main plaintiff who filed the suit, claiming herself as the karta by a widow, did not enter the witness box. No evidence on affidavit was filed by the plaintiffs.
Okay.
And these vital aspects points were raised before the courts below, Lordship, but Your Lordship will not find any whisper, no finding. The impugned judgment is silent, Lordship. on this point. And both the courts below passed the decree in favor of the landlady on the basis of that there is a bona fide requirement and the tenant is a defaulter lordship. Whereas lordship, the tenant regularly deposit when the rent was refused.
Bona fide requirement and defaulter.
Bona fide and default. Apart from that, lordship, I have filed an additional affidavit. In the plain, there is a pleading that her son wants to do his business himself. He is a law graduate son, your lordship. He is serving in a Bombay firm as a legal law officer, Your Honor. And I have filed an additional affidavit, lordship, additional. Your lordship, will you please to take up the additional affidavit filed by the present petitioner on 8/5/2024. This affidavit, lordship, will show your lordship, may please to come to the para 4 of this additional affidavit.
No, which page?
Page, lordship, 111, continuation page. First page, additional affidavit filed by the on 8/5/20.
Yes.
Page, continue page, lordship, 111, para 4. That the respondent plaintiff or para 5 of the plaint in title suit number so and so have taken the plea that the business volume of the respondent plaintiff has witnesses significant growth, and for which the respondent plaintiff require more space to keep their merchandise. Further, in para 7 of their plaint in TS number so and so, the respondent plaintiff however that the suit premises is required bona fide for own use and occupation of the respondent plaintiffs for the purpose of expansion of their business, and the learned trial court, while framing the issue in the said title suit number, has framed the following on the basis of the above mentioned averment, whether the suit premises is bona fide required by the plaintiff for their own use and occupation. Para 5 lordship, that it is humbly submitted that the learned Munsif number 1 Kamrup had decreed the above mentioned issue in favor of the respondent plaintiff in TS number so and the Honorable Additional District Judge number 1 Kamrup Gauhati in title appeal number so and so also affirmed the findings of the learned trial court and held that the respondent plaintiff required the suit premises as there is lack of space for accommodation their expanded business. Para 6, that being highly aggrieved by the judgment and decree passed by the additional decision number Kamrup Gauhati entitled appeal number so and so, the petitioner defendant late Raichan Baradia had preferred the instant civil division. Then para 7 lordship, it is important. And that it is humbly submitted during the pendency of the instant revision petition, it has come to the knowledge of the deponent applicant that Sri Abhishek Moore He is the son of the plaintiff number two. So who is only son of the respondent number two, plaintiff number two, Srimati Kusum Moore, has been residing outside Assam for many years and he is currently working in Mumbai as a vice president legal in an infrastructure investment company by the name of Global Infrastructure Partners. Moreover, the respondent number two, plaintiff number two, Srimati Kusum Moore is a senior citizen aged about 65 years and she has been a housewife throughout her life and as such it is amply clear that respondent plaintiff are not running any business and there is no bona fide requirement of the suit premises for running any business as the only son of the respondent number two, plaintiff number two, Srimati Kusum Moore, is engaged in a full-time job outside of Assam. And that lordship, the document was filed by the petitioner in support of the contention. That document your lordship will find as page 117, that he is serving as a vice president of in a multinational company, page 117. Lordship. And against this petition, Lordship, additional affidavit, the respondent has filed the affidavit in objection, admitting this fact, that the son is working in Mumbai, Lordship. So that because, Lordship, it is well settled law that the bona fide requirement must continue till the final decision of the highest appellate court, Lordship. And in support of my contention, I would like to reply on my appellate court decision, Lordship. Citation is Lordship 1981, 3 SCC, page 103, para 13 and 14. This citation, Lordship, may be pleased to come to para 13 and 14.
Yes.
Para 30. The difficulty which the High Court experienced was whether a tenant under a decree of the eviction could invite the court to take into consideration the event subsequently to the passing of the decree, which, if noticed, would none suit the landlord. Para 14, your lordship, then line from the bottom. Line 10, lordship. Line 10 from the top. Para 40. If he commences the procedure for eviction on the ground of the personal requirement, he must be able to allege and show the requirement on the date of initiation of the action in the court, which would be his cause of action. But that is not sufficient. This requirement must continue throughout the progress of the litigation and must exist on the date of the decree. And where we say decree, we means the decree of the final court. Any other view would defeat the beneficial provision of a legislation like the Rent Control Act. If the landlord is able to show his requirement when the action is commenced and the requirement continue till the date of the decree of the trial court and thereafter during the pendency of the appeal by the tenant, if the landlord comes in possession of the premises sufficient to satisfy the requirement. On the view taken by the High Court, the tenant should be able to show to show that the subsequent event disentitle the plaintiff on the only ground that here is a tenant against whom a decree or order for eviction has been passed and no additional evidence was admissible to take note of the subsequent event. When a statutory right of appeal is confirmed against the decree or the order, and once in exercise of the right in appeal is preferred, the decree or order ceases to be final. So, Your Honor, Lordship, the bona fide requirement must exist, Lordship, up to the final stage of the proceeding, Your Lordship. So that's why this is the admitted fact that the son is holding a very highest post, like vice president in the multinational company and serving there. So there is no bona fide requirement. This is a subsequent development, Lordship. Para 14. Next one. Page 7. Lordship, will you please to page or para? Page. Page 6, Lordship, of the same judgment. Further adjudication.
Which page? Which page?
Page 7, next. Next page, Lordship. If Lordship, the line 1, 2, 3, 5, 7, line 7 from the top.
Which
If the
para?
tenant is
Which para? Para 14?
para 14 continues. Page 7.
No, there is no page number. There are only, in the judgment, there are para number only.
Next page, next page.
Yes.
Line of 2, 1, 2, 3, 4, 5, 6, 7, line 7.
Para 14 is a very large, big paragraph. Yes.
If starts Lordship, if the tenant is in position to show that the need or requirement no more exists because of the subsequent event, it would be open to him to point out such an event, and the court, including the appellate court, has to examine, evaluate, and adjudicate the same. Otherwise, the landlord would derive unfair advantage. And illustration will also clearly clarify that we want to convey a landlord was in a position to show that he needed possession of the premises on the date of the suit, as well as on the date of the decree of the trial court. When the matter was pending in appeal at the instance of the tenant, the landlord built a house or bungalow which would fully satisfy the requirement. If this subsequent event is not taken into consideration, the landlord will have to be non-suited. Can the court satisfy and evict the tenant, such as neither the spirit nor intendment of rent restriction act, which was enacted to fetter the unfettered right of re-entry. Therefore, when an action is brought by the landlord under Rent Restrictions Act for eviction on the ground of the personal requirement, his need must not only be shown to exist at the time of the suit, but also exist on the date of the appellate decree or on the date when a higher court deals with the matter. During the progress and the passage of the proceeding from court to court, if subsequent event occur which is notice would none suit the plaintiff, the court has to examine and evaluate the same and mold the desired decree accordingly. This position is, so this is the well settled law, Lordship. So at this stage, Lordship, when the division petition is pending, the petitioner, that is tenant Lordship, have been able to prove that.
No, under what provision the evidence has been filed at revisional stage? In appellate stage, Order 41, Rule 27 application by.
Fact came to the knowledge of the petitioner.
No, but
the dependency of this division. Because earlier the plaintiffs, defendant tenants were not aware.
But under what provision you will bring the additional evidence on record?
When it is admitted by the landlord, Lordship, plaintiff?
No, I am not disputing. I am not saying that. I am only putting a query as to what is the provision. In appeal, you could have brought additional evidence.
Lordship, the appeal, a title appeal, Lordship, under Order 41, Rule 27, Lordship.
Yes, you could
the
have.
Additional evidence, but at that time it was not our knowledge.
So
at that time he was not serving. The son was not serving.
In pendency of a revision against appellate's court order, what is the exact provision where you can adduce additional evidence? There must be some provision. Otherwise, there will be no end to.
So far my knowledge is concerned, there is no such provision. But the apex court judgment, two judgments I have placed before your Lordship. Your Lordship, it says that any stage of the.
Yes, it says any stage, but
any stage of the.
there must be some provision.
Then the divisional court has the power to remand the back matter to the first appellate court, Lordship, where I will be given liberty to file a petition under Order 41, Rule 27 for giving the additional evidence. But when the fact has been admitted, Lordship, nothing more is required. If that document which I have annexed along with my additional affidavit would have been disputed by the plaintiff, then the matter would have been different.
Here the fact is admitted.
I've disputed. I filed my affidavit, by.
And then I am placing the affidavit filed by my learned friend. Your Lordship, may please to peruse the affidavit of objection filed by my learned friend. Affidavit in reply, sir. It was filed on Lordship 28/5/24. Vague reply has been given, but it is admitted. Lordship, may be pleased to come to page 120, para 7. This affidavit in reply filed by the landlady is dated 28/5/22.
Yes.
Para 7, Lordship, page 120. That the statements made in para 7 of the additional affidavit by the petitioner are not wholly correct, and as such the same are denied by the deponent. It is correct that Abhishek Moore, son of the lady, the son of the deponent, has been residing outside of Assam and engaged in infrastructure investment company in Mumbai. What more is required? Direct admitted fact.
Lord, I will give reply. But exactly the point.
No, you will get your,
Yes, I will get your, I will.
yes, please continue.
Their lordship may come to page 100. Page 20, last part. In reply to this, it is stated that the deponent during the lifetime of her husband was fully engaged in his business with her husband in one of the shops on the ground floor facing Kedar Road, Gauhati, adjacent to the suit premises, and after the death of her husband, the deponent has been continuing and running the same business in the said shop premises as the volume of the business witnessed significant growth. The plaintiff required more space to keep their merchandise for expansion of their business. And so the plaintiffs have brought the suit for eviction of the eviction rights and barrier, the predecessor interest of the petitioner from the suit premises on the ground of bona fide requirement as well as for default in payment of the rent by him. The petitioner respondents have specifically mentioned the matter of bona fide requirement of the suit premises in para 3, 4, and 5 of the plaint, as well in the evidence on affidavit of PW1 Sri Abhishek Moore. It was specifically stated that the PW2, that the plaintiff number 2, Kusum Moore, was running very wholesale business of the potatoes and onions in the name and style of KC Enterprises. Further, in the cross-examination of PW1, it was stated that Srimati Kusum Moore, plaintiff number 2, used to look after the business at the time when her husband was alive. It also stated that after death of her husband, Srimati Kusum Moore has been running and managing the said business herself with the help of employee. The deponent says that the fact of running the managing the whole business by the deponent in the name and style of KC Enterprise in the shop adjacent to the suit premises appears from the latest income tax return and multiple trade business of KC Enterprises. Then para 8 laws. The statements made in para 8 of the additional affidavit filed the petitioner are not correct, and as such same are denied by the deponent. It is stated here that no subsequent development has taken place in the case during pendency of the instant revision petition. It is stated that the fact stated in the plaint with regard to the bona fide requirement of the suit premises to the respondent plaintiffs still exists, and it absolutely false that the respondent plaintiff do not require the suit premises any longer. So these are the averments in the affidavit in reply, Lordship, and the para 7 especially shows that because Lordship, why? Because in both the impugned judgment passed by the learned trial court and the appellate court, the courts below has given a finding that the suit privilege is required for the son of the plaintiff for doing his business, Lordship. And this is a subsequent event.
Yes.
And this Lordship, Abhishek Moore, son of the widow, your Lordship, he was not a listed witness. When the list of witnesses were filed by both the parties, he was not one of the listed witnesses. But without taking leave from the Honorable Trial Court, Lordship, he deposed as a PW1, Lordship.
Yes.
Now, next, I'm coming to the point of defaulter law. Lordship, actually, on a perusal of the documents, Lordship, the petitioner is not a defaulter as per the provisions of section 5(4) of the Rent Control Act, Lordship. Because when the landlord refused to accept the rent, then the rent was deposited in the court. And before that, Lordship, the landlady used to receive the monthly rent for 3-4 months together, Lordship, and which has been exhibited in the suit, Lordship, that there was no fixed due date and the landlady collected the rent as per her convenience, Lord. And in the when the rents were, Lordship, deposited in the court, Lordship, the present petitioner as defendant has filed an application before the learned trial for calling the case record of the NJ cases, Lordship, which would have proved that the petitioner tenant is not a defaulter and he regularly deposited the rent in the court, Lordship. But my learned trial court rejected my prayer, Lordship, for calling the case records of the NJ cases, your Lordship. And list of cycles. List of citations. And in the present suit, what happened, Lordship? The plaintiffs, your Lordship, did not file the documents, your Lordship, before settlement of the issue, Lordship. The documents were filed when the PW1 filed the evidence on affidavit, Lordship. And that is one of the vital defects in the judgments, in the impugned judgment. So I'd like to place before your Lordship our own High Court judgment. This 1992, 1 GLJ, Lordship, page 207, para 11.
Yes.
This our own High Court judgment, Lordship, Sain Guran versus Sri F. Sound and other, para 11. Para 11, Lordship. Under Order 13(1)(2), the parties should produce documentary evidence of any description in their power and position and at the before settlement of the issue. If the documents are not filed at that time, the court shall normally not receive such a document at a later stage unless good cause is shown, if any. Good cause is shown under sub-rule 2 of rule 1 of the order 13 empowers the court to accept such a document. And here in the present suit, your Lord, before the learned trial court, no leave was taken, Lordship, for filing the document at the subsequent stage. So those documents are not admissible in law. And another citation on the same point. H. Lordship, with respect for the according to 1 SCC, page 535, para 4. This citation is Lordship 2002 1 SCC, page 535, para 4. Parties are Madan Lal versus Ramlal.
Yes.
Lordship, may we please come to para 4. Appellant sought to produce certified copy of the order passed by the land acquisition officer, registered sale deed and electricity bills for the genuineness of these documents. There may not be any doubt. Only question is, as the documents were not produced at the relevant time before the settlement of the issue, whether he should be permitted to produce the same before his evidence is recorded. It is true that there cannot be any serious objection to production of such a document which cannot be doubted. At the most, question would be in a rebuttal. Plaintiff should be given some opportunity to lead the evidence, but that can be done by the court at appropriate stage. So here, Lordship, at the appropriate stage, Lordship, when the documents were filed subsequently, no leave was obtained from the court, Lordship, as provided under the CPC. And on this point, there is a leading judgment of this honorable court. Nepal, Nepal.
This plea was taken before the appellate court.
And these pleas were taken. These pleas were taken before both the courts. Nepal, that's the thing. Yes, 2011.
Because in revision, this court's jurisdiction is limited jurisdiction. It cannot examine entire evidence unless
That is correct. Your Lordship is correct. I am admitting it. But here, Lordship, these are the this procedural laws. At least a document, if it's not disputed, Lordship, that can be allowed to be filed. But taking leave is mandatory, Lordship, either under section 30 of the CPC or under 30. Leave is required. This is the leading judgment of our own High Court is the citation is a court of dismissal. 2011 5 GLR Lordship, page 23, Nepal Das and others versus Aditi Devi and others. Relevant paras are Lordship 53 and 54. Para 53 Lordship. Fallout of the above discussion is that if a plaintiff or the defendant does not, while presenting the plaint or the written statement, as the case may, produce the document on which the suit or the suit is claimed, as well as the documents which relied upon as a piece of evidence to support his case, the plaint or the written statement. The case may be debars himself from producing such a document at the time of settlement of the issues or call for production of such a document. The provisions contained as a regards settlement of the issues leaves no room for doubt that at any stage before settlement of the issues, all the documents in original where originals had not been delivered at the time of presentation of the plaint or the WS must be placed before the court. It is with the settlement of the issue that the hearing of a suit commences. Para 54. Para 54. It is in this regard necessary to take note of the fact that before issues are framed by issues are framed, the document must come on record, and if the and it becomes the duty of the court to ensure that in terms of the requirements of the order 12, notice is given by a party to the other side for admission of the documents. If any, in fact, the order 12 rule 3A empowers the court to record admission at any stage of the proceeding motion, and on such admission even a judgment can be given in terms of the order 12 rule 6, when inspection of the documents and records, if any, is over. Documents are brought on record, and after documents, if any, are admitted, the stage for framing of the issues arrives. Naturally, the issues must indicate as to who is the party or whom the burden of proof lies, and it is in accordance with the burden of proof that the evidence has to be recorded. So, Lordship, in the present case, your Lordship will peruse the records of the trial court, Lordship. Will prove that the documents were not filed by the plaintiff before framing of the issues, Lordship. So those documents cannot be, judgment cannot be based upon such inadmissible documents. The other regarding Lordship, the acceptance of the rent, I would like to place our own High Court judgment, 2063 GLT, page 72, para 16. Para 16 from the bottom, Lordship, line in the middle, your Lordship will find in the full bench judgment,
Yes.
in the full bench judgment in Kali Kumar Sen, Supra, it was provided, observed that the rent has to be deposited within time limit agreed upon as per the contract of the contract, if there be any. A contract may be in writing or it may be oral, as well as in case in hand. There was a written contract, but the parties did not act upon the same insofar as the due date is concerned. Landlord demanded whatever he, whenever he wanted for 1 month or many months, at that time, at a time, and the tenant also paid accordingly. So it cannot be said that parties had agreed upon to make payment of the rent in the first week of the succeeding month as per the English calendar. In the case in hand, there was no due date as there was no fixed date for the payment of the rent. Parties did not act upon clause 3 of the Exhibit 1 and 2 agreement, and by practice they did always with the did away with the provisions of the payability of the rent in the first week of the succeeding month. In the case in hand, there was no due date by agreement of the parties in view of their conduct for long period over 15 years, and so it is not possible to hold that the clause number 3 of the Exhibit 1 and 2 will be binding. Will be binding on the tenant, since he would like to. There was no due date. The question of committing default cannot arise. The learned courts below have committed error in holding that the tenant is a defaulter for not having complied with the requirements of the clause 3 of the agreement, insofar as it relates to a due date. Here in the present case, Lordship, from the you also may please to peruse the WS Lordship filed by the petitioner, differently. That your Lordship will get at page 54. Page 54. Or 34, sorry. Thank you.
Yes.
Page 34 is the WS filed by the petitioner defendant.
Yes.
Your Lordship, may please to come to page 37. 37 para I. Para I at the bottom. Rent for 3 months, total amounting to sum of rupees 15,963 at the rate of rupees 5,321 per month were collected by the plaintiff from the defendant at a time by check number so and so. This check was amount were collected from the defendant's bank account number so and so. This shows, Lordship, that for 3 months the rent was received by the landlord, Lordship. Then Lordship may come to next page, para 8, Roman 8, at the bottom. Rent for 3 months. Have you got it?
Yes.
Page 38, para Roman 7. Rent for 3 months, total amounting to a sum of rupees so and so of itna per month were collected by the plaintiff from the defendant. At a time by check number so and so, the said check amounts were collected from the defendant's bank account number so and so. Then Lordship, Lordship, may please to come to page 41. Lordship, a termination notice was given by the learned counsel of the plaintiff Lordship. In the agreement, Lordship, there is a clause that if the tenancy can be terminated only by giving 3 months advance notice. But here in para 11, Lordship, page 41, only 12 days notice was given. So I am placing the para 11. That as regard the statements made in paragraph 6 of the plaint, the same are not fully correct and hence are not admitted. It is stated that on 19/3/2011, while the defendant was busy in his business or in tenanted premises, he received an advocate notice dated 18/3/11 issued by and on behalf of Srimati Kusum Moore, plaintiff number 2, where this notice was not given in the individual name of Kusum Moore, Your Lordship, not as a Karta of the HUA, that exhibit is in the trial court Lordship. Informed that Srimati Kusum Moore is not interested in renewal of the tenancy agreement which expired on 30th March 11. And thereby a direction was issued to the defendant to hand over the possession of the tenanted premises to Srimati Kusum Moore on or before 31st/3/2000 along with payment of all dues. The said notice was issued by the advocate of Srimati Kusum Moore, although as per the tenancy agreement dated 1/8/2008, Srimati Kusum Moore is not the owner of the tenanted premises, because Lordship, the owner was HUA, not the lady. In fact, the owner of the tenanted premises is MS Kishori Lal Vijay Kumar, which is a HUF, and Srimati Kusum Kumar act as the Karta of the HUF. The above mentioned advocate notice is not issued by and on behalf of the actual landlord, and was therefore an unauthorized notice was not binding upon the defendant. However, even if the said advocate notice is deemed to have been issued by the landlord, then also the said notice simply directs the defendant to vacate the premises on or before 31st/3/2011 and does not disclose as to why the defendant was directed to vacate the tenanted premises. The said notice for vacation of the premises was arbitrary, illegal, and not enforceable in law, as in case of the said notice would have been complied with, then the defendant would have suffered irreparable loss and injury, and the same would have been resulted from curtailment of the defendant's livelihood and livelihood of the family members of the defendant. Then Lordship, regarding bona fide averments, Lordship will find page 43, para 12. That as regard the statements made in para 7 of the plaint, the same are not correct and hence are not admitted. It is stated that the suit privilege is not required by the plaintiff as they have used sufficient alternative place for expansion of their business. As regard the expiry of the tenancy agreement is concerned, it is stated that the same is not a registered document instrument and as such same is not admissible.
No, we will not go into these. We will only consider your on what grounds appellate court's judgment is wrong, beyond jurisdiction.
One thing, Lordship, I'd like to place before Lordship that the defendant regularly deposited the rent in the court, that your Lordship will
Yes.
page 45 of this WS Lordship. Lordship, each month, your Lordship, I have given the details, month, year, amount deposited by the tenant defendant. And all rent
On
deposit.
what ground the trial court held you to be defaulter?
Only on the ground that the rents were not paid on the due date and the rent deposit which have been deposited in the court that has not been taken into consideration, Lordship. The Lordship is pleased to peruse the improved judgment regarding the default that your Lordship will. Yeah, improving judgment by the London Trial Court is Lordship at page 17. Page 14. Oh, sorry, 14.
Where is the appellate court's judgment?
Appellate court judgment. 87.
87.
Yeah.
How it dealt with the defaulter issue?
Most cryptic and vague manner, if not 87. It starts from page 87 regarding issue of defaulter Lordship. Issue number 4 is whether the defendant is a defaulter in payment of the rent. And that has been dealt. Issue number 4. Page 93. 90? On perusal of the para 14 Lordship, page 93. On perusal of the evidence of PW1 reveals that the said witness in his evidence deposed that the defendant failed to pay the rent of the tenanted premises since 1/4/2011, which the defendant, while cross-examining the aforesaid witnesses, challenged by bringing the fact that the defendant offered the rent for the month of April 2000 in the first week of May, but it was refused to be accepted by the plaintiff number 2. It appears that the defendant has DW1 in his examination in chief deposed that the rent was for the month of April 2011 was offered by him to the plaintiff as an enhanced rate through check number so and so. It is pertinent to mention that perusal of the entire evidence on record reveals that the defendant failed to prove the said check is substantiated the lawful offer as alleged to have been made by him, which is the prerequisite to prove valid payment of the due rent. Whether it is pertinent to mention that surprisingly the defendant in his evidence while getting cross-examined categorically admitted that the rent for the month of April 2011 was offered by him in the first week of April 2011 itself, which itself appears to negate the lawful offer as claimed to have been made by the defendant, the plaintiff number 2. This is the only, and then Lordship, this para 50. It is further pertinent to mention that the defendant further deposed that after the refusal of the rent to be accepted by the plaintiff for the month of April 11, he deposited the same in the court by Miss J case number so and so, the record of which is proved as Exhibit B series by him. It is worthwhile to mention that subsection 4 of section 5 of the Assam Resident Control Act 72 clearly says that when the tenant deposited the rent which is refused to be accepted by the landlord after being offered in the court, then such rent should be deposited in the court together with process fee for service of notice upon the landlord, and on receiving such a deposit, the court shall cause notice of the receipt of such deposit to be served on the landlord, and the amount of the deposit may thereafter be withdrawn by the landlord on application made by him in the court on that behalf. But in this context, it is pertinent to mention that the perusal of the evidence of the defendant clearly reveals that it is admitted fact that while depositing the rent for the month of April 11 in the court, no process fee was submitted.
So that was the ground.
That was the only ground, but Lordship already had submitted before Lordship that earlier Lordship on 2 occasions, rents were clearly accepted by the landlady Lordship for together for 3 months.
No.
3 months Lordship.
No, even if we admit that,
Ah,
the one of the ground for treating you as defaulter by the trial court was that while you deposited the rent before the court, process fee was not there, and no notice could be sent to the. That was found to be a defect, which was held to be rightly decided by the appellate court. Appellate court also discussed this in its judgment. So where the appellate court is wrong?
Lordship, when it was proved by the petitioner tenant Lordship that the landlord used to take the rent 2-3 months together Lordship at a time. So there was no fixed due date. That is my submission. Already I have placed in support of my contention our own High Court judgment and the Supreme Court judgment Lordship. When the mode of, in spite of having a contract, a written agreement Lordship.
No, trial court discussed this from a different angle. It said that even if when you started depositing the rent in court, you did not deposit as per the requirement of law.
Only in case of the rent for the month of April 2011.
Yes.
Only.
Even one default is sufficient to.
One default is sufficient, but where it is a case that the rents were accepted by the landlord 3 months together, that will not be proper to pass a decree on the ground of defaulter law.
No,
Because I have paid I have deposited the rent, your lordship. These are technical procedure lordship. Procedure law cannot be the master of all substantive law here. That is purely a procedure law. So, your lordship, please to consider that what the landlord or landlady should get the rent. Rent was deposited. Whether
but if you deposit the rent and if you don't inform the landlord that I have deposited
in the WS, each and every deposit details NJ cases have been shown. No. That was not considered by both the courts below law.
Court has, you make me understand, trial court held that when you deposited the rent in court, you did not issue notice to the landlord. Therefore, landlord was not aware whether you are depositing it or not. You did not pay any process fee as required under law. That was also one of the grounds for treating you as defaulter. And this point was considered by the appellate court also, appellate court found the trial court right. Now you have to make me understand where the appellate court judgment is wrong on that.
Wrong on the point, Lordship, is regarding the finding that the process fee was not paid, notices were not served.
Yes.
That was to be decided by courts the below on the basis of the pleadings or the evidence on record, Lordship, given by the tenant or petitioner, Lordship, which shows that the rents were accepted by the landlady 3 months together, not only one or on many occasions. That part has been totally, while deciding the defaulter point, that point ought to have been decided, taken into account. The
No,
deposit of
let us assume, if we accept your argument that the tenant was not defaulter in paying rent for 3 months, 2 months together. Let us assume, accept your argument. Then you started paying rent at some point of time before the court. You are not paying rent to the landlord directly. In the court,
this time offer was given, land was offered.
rent was offered, she refused,
She refused,
then you paid to the
because
court.
without refusal, one tenant cannot deposit in the court.
No, that we accept that. Suppose there was a refusal also, and therefore you were compelled to deposit the rent in court. But if in court you don't deposit it as per legal requirement, then whether you will be regarded as a defaulter. On that count, you have been held as defaulter.
Lordship, if there the NJ cases were not filed properly, written up notices is not given, notices not issued.
Yes.
All these are procedural laws, Lordship. In that case, a tenant can be, there are judgments that tenant can be declared as a default. There is no doubt. But here the case is a bit different, Lordship. When the landlord used to accept the rent for months together, Lordship, when there was no due date. The finding of both the courts below, what is finding? That the rents were not paid by the tenant or deposited in the court on due dates. On due dates. So when there was no cut-off due date due to practice between the parties, Lordship.
So in cases where there is no cut-off due date, the tenant can never be declared as defaulter. Is that a submission?
Lordship, that if there is such circumstances, Lordship, there is no due date, fixed, Lordship, so land can be paid at any time. At any time. It depends upon the decision of the landlord and the tenant law. If the generally, Lordship, and the landlord demands rent, Lordship, the tenant gives the rent for, in many cases it is found for months together, Lordship. Here also the rents were paid. And that depends upon the conduct of the landlord and the tenant, Lordship. Here the conduct of the landlord and tenant show beyond doubt that the landlady used to receive the rent from the petitioner defendant for months together.
No, okay.
That point has
Listen to my query. My query is, the trial court regarded you defaulter on 2 counts. First one is
defaulter and
you was found defaulter for a particular month, April or some month.
Only April 2.
And second count is that you failed to validly make valid deposit in the court due to non-following of some procedure of paying process fee, issuance of notice. On that count also you were found to be defaulter. What is your submission regarding the second part? Regarding first part, even if I admit that the tenant used to deposit rent for 2 or 3 months together, even if we admit that, how will you justify the second reasoning of the trial court?
The second reasoning of the trial court, actual position is the rent was deposited, already I have submitted.
Yes.
Process fee or the.
Court held that it was deposited, but it cannot be considered as valid deposit.
That's why, valid deposited on or before due date. Always your lordship may be pleased to consider that defaulter is adjudged on the basis of the due date. Here there was no due date, though there was a contractual agreement between the parties, but the conduct of the parties changed the date of due date. If there is no due date, lordship, a tenant cannot be held defaulter, and I have already placed the apex court judgment also on this point. Lordship. And apart from that, Lordship, my humble submission, if it is held that the suit is not maintainable.
Yes, no, that is a different argument.
Will,
What submission he will make, I will have to consider.
no, that is linked to.
If suit is not maintainable, everything goes. That is your submission.
My submission. The suit itself is not maintainable, and this vital, it means, Lordship, both the courts below have no concept regarding the law of HUF under Mitakshara School of.
No, but whether have you pointed it out to the courts?
Yes, I have pointed out.
There is no reflection.
No,
They-
it is not maintainable. This plea, first plea is there.
On what count? That you have not, have you stated in your written statement that it was not maintainable because the plaintiff is a female and she cannot be regarded as co-par?
The cross examination of the PW1, that is the son, he himself had admitted this fact. Lordship, and these are pure question of law, Lordship.
No, but even if it is a question of law, unless it is pointed out to the court, trial court or appellate court.
Then it is also the duty of the courts below, Lordship, to first of all, while admitting the plaint, Lordship, under the CPC, court has to examine whether the suit is barred or not under any provision of law, and whether the suit is maintained.
Yes, if something is.
Preemptory hearing.
Yes, yes. If something is missed out, you have to point.
The courts below, it appears that has no idea or concept regarding the Mitakshara School of Hindu Law of HU. Just your lordship may be pleased to peruse the evidence of the PW1, where he has admitted that her mother was the Karta.
No, okay, that is okay. Yes, what else is your submission? Anything else?
Lordship, already I have submitted. I have the trial court record only revealed. I have filed an application for calling for the NJ cases record. That was, application was refused, rejected, Lordship, by the learned trial court. So I was not given opportunity to prove my deposits, Lordship.
When it was rejected?
It was rejected, Lordship.
My lord, to that, my lord, it is absolutely wrong statement, my lord. Already record was called for. It has been exhibited also.
No, the record.
Yes.
Trial court record the
Yes, I will show.
Yes.
I have put the cross examination.
Trial court record.
Ramesh, trial court record.
So twice he has submitted.
No, you just point out where.
नहीं है ना.
You just tell me the date on which your application. Trial court record the auction. And assuming that it was rejected, you could have preferred.
That he had taken in the memo appeal. while filing the title.
No, against that rejection order, you were not remediless.
No, your lordship is correct. I would have preferred the 227 petition or
Yes.
what lordship when I filed title appeal.
What was the date of rejection? Okay, this you pointed to me the date later on. You can proceed with further argument.
Former petition in the case of order reject petition. To order.
Anything else?
Yes, it can. Just one cross examination of the PW, 1, 2, 3 line I'd like to post. It is affidavit in opposition. Response, revision of affidavit in opposition. Lordship, be pleased to peruse my learned friend. I filed the affidavit in opposition in the present proceeding.
Yes.
Lordship, the cross examination, your lordship will find at page 100. Page 12. Page 12.
Yes.
This is the cross of PW1, Abhishek Moore. That is the son of the lady.
Yes.
The Karta of the plaintiff, Srimati Kusum Moore, has not given any power of attorney in my favor for giving evidence and appearing in the court in connection with the suit. But by Exhibit 10, the Karta of the plaintiff by writing her authority to represent the HUF Kishori Lal Vijay Kumar and to appear and plead act or depose in the suit. Exhibit 10 is not a stamped or registered document. Simply, Lordship will not do. As per the provisions of Order 1, Rule 12, Lordship, if authority can be given to one of the plaintiffs or one of the defendants, Your Honor. That is the provision under Order 112 of the CPC, that if there are more than one plaintiff or more than one defendant, Lordship, then some of the plaintiffs or defendant may authorize one of the plaintiff or defendant to represent the other plaintiff and defendant. But in the present case, Abhishek Moore is not a party to the suit. He is a stranger to the suit. There is no averment in the plain lordship that he is one of the co-partners of the HUPF. Further question. Shooter record 90. Title episode. Exhibit বিলাক ট্রায়াল কোর্ট হতে থাকে। এলসিআর আইছে কিন্তু বোধহয় সেকশনে পড় হয়।
This is of the appellate court.
Trial court's record will be required.
No, okay, you make your submission. Yeah. You continue with your submission.
I'll continue, Lordship, but.
That cross-examination portion is there,
Yes.
which you are
page
referring.
12 of the.
Yes. Yes, what you want to point out?
Point out, Lordship, here is Abhishek Moore, son of the widow, is PW1 now. He deposed that the Karta of the plaintiff, Srimati Kusum Moore, has not given any power of attorney in my favor for giving evidence and appearing in court in connection with the suit. But by Exhibit 10, the Karta of the plaintiff in writing has authorized me to represent the HUF Kishorilal Vijay Kumar and to appear, plead, act or depose in this suit. Our Lordship, see, the exhibit is simply written on a white paper, Lord. Whether that can be treated as a valid authority when there is no power of attorney. No, Abhishek Moore, he is not one of the plaintiff or the defendant. So he cannot represent the plaintiff as per the provisions of Order 1, Rule 12 of the CPC. Further, Lordship. The suit is filed by my mother, Kusum Kumar Moore, as Karta of the HUF, Kishorilal Vijay Kumar, as well as in the individual capacity, and she has verified the claim and also sworn affidavit in support of the case. My mother has not appeared to depose in the suit. It is not a fact that I am not entitled to depose on behalf of the plaintiff. It is not a fact that the exhibit 10 is invalid and unenforceable document. That the instant suit is filed on 1/2/2012 by the exhibit 10, while the exhibit 10 was issued on 1/10/30. Your Lordship, be pleased to note that while the suit was filed, there was no any authority given to the PW1 Abhishek Moore, Your Honor. This white paper writing was on 1/10/2013, Lordship, where the suit was filed on 2012. On 19/6/12, the list of the witnesses of the plaintiff was filed wherein names of the witnesses were mentioned, but my name was not mentioned in the list. No permission was sought from the court by me for depositing on behalf of the plaintiffs. Then, Lordship, next page, page 13, page 13. It is not a fact that I am not a listed witness, hence my evidence is not admissible without the leave of the court. Exhibit, this is important. Exhibit 1, tenancy agreement. There is no clause or terms to the effect that tenants shall have to vacate the tenanted privileges for bona fide requirement of the landlord. So this is where my submission, why I placed before our Lordship. The PW1, son of the plaintiff number 2, himself deposed that Kusum Moore, that his mother is the Karta of the HUF. It should immediately click in the minds of the lower court's Lordship that whether a female can represent the HUF Lordship as a Karta. And under the natural law. So these evidences were not discussed. No finding in the impugned judgment, Your Lordship will find. Your Lordship may be pleased to peruse how my application. All records and NJ cases were not produced before the learners in spite of our prayer. I am having the certified copy, Lordship. Some of the NJ cases have come, and when I prayed that all NJ cases should be called to prove that I am not a defaulter, my petition was rejected.
On which date?
I have given the 24. 20. The 20th of April
2015.
15.
These are regarding subsequent months,
It would
not
be
for April. appraisal was exhibited.
Whether it was for which one, that is not material, Lordship. Whether opportunity was denied to me, Lordship. Because on the basis of the challenge and the NJ cases, Lordship, it is decided by courts whether a tenant is a defaulter or not, and whether before or due date the rents were deposited in the court. That opportunity was denied to me
No,
by rejecting my
but
petition.
you could have challenged that order.
I have challenged by filing the title appeal. If your lordship want to say that why I did not file the revision petition before this honorable court, so that when that remedy is available in the title appeal, if on any ground lordship, if the trial court has rejected or committed any illegality, lordship or illegality, in that event that can be considered by the appellate court. Appellate court did not go, no, whisper your lordship will find in the impugned judgment passed by the learned appellate court, which has caused great prejudice, lords, to the petitioner.
Okay. Yes.
But there are some exhibits, lordship, which I would like to place, but that is trial court record is not here. Some exhibits are very important.
What exhibits?
Exhibits.
Which exhibits?
Exhibit by the plaintiff as well as by the defendant. Tenancy agreement like that, because in the pleading lordship, the plaintiff has placed, there is a clause in the agreement that on the bona fide requirement, the tenant will be bound to vacate. But whereas in the agreement tenancy, there is no such clause. For doing the substantial justice, lordship, your lordship I have concluded my job.
Okay, let me hear the other side. How he overcomes the question of maintainability.
For the first ground, which my learned brother has raised regarding that
Maintainability.
Yes. My lord will find from the title suit which was filed by this plaintiff, my lord. Here the title is that, my lord, the plaint is there. I am referring the plaint, my lord. At page 27.
Yes.
Page 27, the plaintiff is Kisorilal Vijay Kumar is the actual.
Yes.
HOF is one of the plaintiff, and then Kusum Moore is the another plaintiff, who was the Karta.
Yes.
Karta, why, my lord? The husband died, and this Abhishek Moore, he was minor at that time. So she was representing the Karta. The HOF cannot come to an end. As when the husband died, the HOF cannot be comes to an end. That is the law says, your lordship. And then, my lord, there was an agreement with that title, Kisorilal Vijay Kumar. That agreement, he has signed it. Then, my lord, not only that, he was paying rent in the name of the Kisorilal Vijay Kumar. Check, he was doing the check in the name of the Kisorilal Vijay Kumar.
No, who is the landlord?
Landlord is Kisorilal Vijay Kumar HUF.
Oh, his submission is that Kusumur
No, Kusum
cannot represent.
No, Kusumor was not the landlord. Kusumor just representing the HUF. HUF was the landlord. My lord will find the tenancy agreement is also there.
But a female cannot be an Karta.
I have some authority also. First of all, I am just making clear about the factual position of the case, my lord. I have one tenancy agreement. Here your lordship will find the tenancy agreement is there. In that, HUF was the landlord. And then, my lord, he was paying the rent in the name of HUF. the payment was, system was that, my lord, he was issuing check, account pay check in the name of the Kisorilal Vijay Kumar. And that amount was to be encased by depositing the check in the account. That process was going on. Thereafter, my lord, when the tenancy came to an end, a notice was sent to him. Then he went to a civil suit for declaration of the tenancy by implementing that tenancy agreement to be he sought for a declaration that there was a valid tenancy on the basis of the tenancy agreement, and the court has decreed the suit. The court has decided that there was a valid tenancy between the plaintiff and the defendant.
Plaintiff is Kishorilal Vijay Kumar.
Yes, Kisorilal Vijay Kumar. That judgment also we have exhibited here in this suit. So that
What was the case number, title, suit?
I am giving that back.
No, even if it is accepted,
Yes,
the tenancy was declared to be valid.
yes,
It was valid between the present appellant and the HUF.
HUF.
And his submission is that you cannot represent the HUF.
No,
You are a female,
yes. On
and
that,
female cannot be karta of.
that, my lord. Here the question is that the suit is of a ejectment suit, my lord. Here the only moot question is to be decided, the relationship of landlord and tenant. You have
No,
accepted-
but somebody has to represent the HUF.
Yes,
Who is representing HUF?
that Kusum Moore was.
You projected yourself to be karta of the HUF.
Yes,
His main plea is that a female cannot be karta of
Yes.
HUF.
that plea was that,
Oh.
but in the written statement, he has not taken that plea, my lord. I am showing the written statement. He has simply taken that suit is not maintainable. And the issue also,
His submission is that this is a question of law, which
But-
can.
but my lord, even if it is a question of law, he must have to say that why the suit is not maintainable. Because in the judgment, your lordship will find in the trial court,
He's saying now. Now he's saying.
now he is saying.
He says that the question of law can be raised at any time.
That cannot be only absolute, because even if I say that suit is not maintainable, I have to say for what ground the suit is not maintainable. Because a trial court's judgment, your lordship will find, so far the issue number one,
No.
maintainability of the.
You
suit-
answer one query,
Yes.
assuming that plea was not taken.
Yes,
But courts, now it comes to court's notice that
yes,
there is a legal bar
Yes.
in Kusum representing as Karta of HUF.
yes. But,
Then you have to satisfy the.
but my lord, that the plaintiff was that Kusum Moore as well as the HUF. HUF.
But
the
who is
principal
represent?
person.
Who is represent? HUF can be represented only what CPC says by its Karta only.
By Karta.
Karta only.
By Karta,
But-
manager.
But Kusum cannot be a Karta. He has cited a judgment that
He is kind of.
only after amendment of 2005
Yes.
in Hindu Succession Act, only daughter can be a co-parsoner along with.
My lord, the judgment which my learned brother has just referred, 2015, there also the court not decided that the woman cannot be the karta. It is a reference was made from the income tax law, which was cited by the other side.
No, you satisfy me that
Yes.
woman can be Karta
Yes, my lord.
in,
I think the
in the second half.
second half.
Yes, anything.
Regarding item number 23, I have taken the concern of the other side.
Item number 23, SP Sharma. prays for an adjournment. Format একে থাকিবে SI account does not object to the same. Prayer is allowed. List this matter after 4 weeks.
Being the first one amongst the co-partners of the accused property, would by virtue of her birth being entitled to be the Karta held, no restriction in law preventing eldest female member co-partner of the accused from being the Karta, para 28. Here, that case which has been referred by in the Supreme Court, Commissioner of the Income Tax versus Madhya Pradesh, that has also been discussed, my lord. 1966 Supreme Court. And in the relevant para, my lord, relevant para is para 27.
What it says.
Para 27. What emerges from the above discussion is that impediment is prevented a female member of a accused from becoming its karta was that she did not possess the necessary qualification of co-partnership. Section 6 of the Hindu Succession Act is a socially beneficial legislation. It gives equal right of inheritance to Hindu male and female. Its objective is to recognize the right of the female Hindu as a co-partner and to enhance their right to equality approach succession. Therefore, the court would be extremely vigilant approach may endeavor to curtail or better the statutory guarantee of the enhancement of their right. Now, this qualification has been removed by 2005 amendment. There is no reason as to why Hindu women would be denied the position of a karta. If a female
No, the submission of learned counsel for the petitioner was that section 6 enables only daughter to be co-partner.
Yeah.
Unless she is daughter, she cannot be co-partner. Unless she is a co-partner, she cannot be karta.
that effect, my lord, there is no specific that decision is not there, my lord. In Supreme Court also, this point has not been specifically decided by. A reference was quoted, but there is no finding of the Supreme Court upon that, my lord.
No, section 6, you go to section 6 of Hindu Succession Act. Because this point is an important point.
Yeah.
You have to jump.
Daughter has been implemented by section 6, my lord, that amendment. Hindu
Yes.
Succession Act. There's co-partner. After 2005 amendment.
So daughter of a co-partner can be a co-partner.
Yeah.
But here whether Kusum Devi,
My lord, the suit was drawn in the name of two persons. One is Kusum, other is the HUF. Now,
no, that is his objection, that HUF cannot be represented by a person who is not a co-partner. And
HUF itself is a juristic person. my lord.
yes, somebody has to represent HUF.
He will not be the Karta, then, although the situation was like that, my lord. The husband died and the son was a minor.
Yes,
So there was nobody,
she can at the time of filing of the suit.
yes. And there was nobody to represent her. So he represented as a manager, like that. Although this commonly word the Karta has been used, my lord, but only if that.
Your submission is she can be treated as a manager due to minority of her son.
That act, that provision has been recognized by the Supreme Court in number of decisions, my lord. One of the decisions, my lord, may I refer? That is in 2025 Supreme Court. In a suit for erection, proof of ownership.
Which para?
Yes, data is my lord. Para 10. 1670. 25 Supreme SC 167.
Yes, what you want to say?
Para 10, in any event, the ground on which the will was here, my lord, the question was raised that the landlord has no right to bring the suit for ejectment, my lord. So upon that, the court has decided that in any event, the ground on which the will was suspected by the trial court cannot be upheld. It was admitted by the defendant that prior to and after the death of Ramjila, the rent was paid to the husband of the plaintiff. It is the contention of the defendant that prior to the landlord's death, his son collected the rent from them on his behalf, and after his death, they paid the rent, accepting his status as a landlord, being son of the original landlord. The dispute raised in so far as the ownership of the Ramji Das cannot at all accepted, since Exhibit P18, the relinquishment deed issued by Sualal as far back as 1953, on the strength of which Ramji Das had given the disputed soap room on rent to the father of the defendant, is clearly established. The tenant having come in possession of the tenanted premises by a rent deed executed by the earlier landlord cannot turn around and challenge his ownership. It is only an admitted fact that from 1953, the predecessor of the defendant and the defendant after father's death had been paying rent to the said Ramji Das. The dispute regarding the title of Ramji Das could not have been raised by the tenant who had come into the premises by virtue of the deed executed by Ramji Das, to whom for more than half a century the tenants were also paying the rent.
No, in this case, the issue is not that whether you are, but here title is not disputed. In this case, they are admittedly your tenant. They are saying we are the tenant of HUF, but the suit could not have been filed by the person, by that lady, Kusum Moore, showing herself to be Karta.
Let us examine the plaint, my lord. At page 27.
Yes.
See, the suit was brought in the name of two persons. One is artificial person, that is Kishori Lal Vijay Kumar. It is juristic person. Then Kusum Moore. So it cannot be that suit cannot be maintainable. HUF is also a juristic person, my lord. And even if it her contention that she is the Karta, she may be as a manager of the property, my lord, because nobody was there in the male member in the family.
No, but whether statement to that regard was made in the plaint.
My lord, that title was never disputed even in the written statement, neither in the evidence, nowhere it has been disputed.
Okay.
No question was raised during the trial, in the appeal, as well as in the revision also, my lord. No ground has been made. And my lord, the judgment which has been passed by the trial court upon the issue of maintainability, I am referring that part of the judgment, my lord. Page 49. And the particular issue was framed, my lord, at page 52. Whether the suit is maintainable. Now, before that, my lord, I will refer their WS part. What plea in written statement they have taken. Page 34 is the WS.
Yes.
In the WS, my lord, the only one statement they have made that suit is not maintainable in law as well as in fact and is liable to be dismissed. If somebody says that suit is not maintainable, he must have to say why it is not maintainable.
Yes.
For want of non-addition of the party or for other irregularity, what was that irregularity? You must have to say it. Nothing is that, my lord. Now, in the issue what has been decided by the trial court, I am coming to that, my lord. It is at page 54. The trial court has decided. Page 54. So far, the issue number 1, maintainability of the suit is concerned, it is seen that defendant has raised this issue initially, but during evidence hearing as well as the argument of the defendant has not raised any issue, point as to show how and under what provision of law the present suit is not maintainable.
Okay.
In that view of the matter, simply by saying that suit is not maintainable, now at this stage of the suit, when there is a concurrent finding of both the court, that he has defaulted in payment of rent, and the suit is required bona fide by the plaintiff. So, by not giving reply to that issue, my lord, he is coming on the technical ground.
No, but once the question is raised, you have to satisfy that on law it is maintainable.
That is true, my lord. But the thing is that I have already.
In law it is maintainable.
Yes, I know it is maintainable. And so far, my lord, the other part of the argument is concerned, my lord. He has made some argument. So before that, my lord, this issue that regarding the ejectment suit, the court is to look into only the relationship. That upon that I have referred the judgment. There are other judgment also upon that. There is, my lord, 2006 5 SCC, page 532. Here also, the court says that in an ejectment suit, the court is only to look into that para is specifically para 5. Para 5 is that. Para 5 and para 11. The High Court, while exercising the power under 227 inter alia, that appellant were liable to be evicted on the ground of subletting and non-payment of rent. It was also found that the appellant were inducted by Paidama alone in the property in question, although at the relevant point of time, she did not acquire any right, title, interest in the properties in question on the death of the first wife, Chakma. On the date of civil division, case was allowed and the application for imprisonment was so. Thereafter, my lord, the matter went to Supreme Court, and what Supreme Court has decided ultimately in para 17, 18. Supreme Court has decided in the interim order, the High Court held that it was Paidama respondent number 1 who had inducted the appellant in the properties in question, and it was also the finding of the High Court that and also the trial court that the appellant continued to pay in respect of the property in question for some period and thereafter stopped payment. On such finding, the High Court held that it was not open to the appellant to deny the title of the properties in question of Paidama in view of section 116 of the Evidence Act. This view was also recognized by this court in Atem versus so similar view was also expressed in the later decision of this court in Pez on Madan, in which it was held that tenant was precluded from denying the title of the landlady on the general principle of estoppel between landlord and tenant. It was held that principle in its basic foundation means no more than under certain circumstances law considered it just to allow a person to approbate and reprobate. In our view, 116 of the Evidence Act is clearly applicable in the present case as held by the High Court in the interim judgment. The finding of the fact that High Court and the trial court that the appellant were not let in possession by the Paidama and the possession of was not restored to her by the surrender was based on the consideration of material evidence on record which cannot be disturbed. Therefore, in our view, if the respondent Paidama was not entitled to inherit the properties in question of Puri Narayan, then also she could maintain the application for eviction and obtain a decree order of eviction on the ground of default and subletting the AP Tenancy Act. So here, my lord, not only that the tenancy agreement was executed, and in the tenancy agreement, my lord, she stated herself to the Karta. That document both parties have executed. Thereafter, my lord, when I sent the notice, he filed a suit against the landlord on the basis of the same tenancy agreement with the prayer that the declaration that he is the tenant under that Kisorilal Vijay Kumar represented by Kusum Moore as a Karta. And that declaration is sought for.
In which title suit?
In title suit, my lord, that has also been referred in cross-examination part. I have exhibited also, my lord. That title suit was 133 of 2011. By Munship to Gauhati. And that has been exhibited also. I am referring the exhibit numbers. Exhibit number, my lord, a certified copy of the judgment dated 18/1/2013 delivered in title suit number 133 of 2011 by learned Munship to Gauhati. Exhibit 5. Exhibit 5 is that judgment and Exhibit 6 is the plaint of that suit. So, when there was a decree, and the decree was passed on the suit which was brought by the tenant himself against the landlord. And what for this suit was actually
Whether copy of that
that has been exhibited by it. Yes, I have got the copy, but it is in photo state, my lord. A certified copy, photostat copy of the certified copy of the judgment as well as the plaint. I think plaint is also there. Yes. Yeah. More.
What was the finding? What was the finding?
Yes.
That the present petitioner is a tenant of
Yes, my lord.
HUF represented by
First of all, I am referring the plaint. Plaint in the plaint suit was Sri Raichand Bararia, who is now the petitioner here, against Kisorilal Vijay Kumar, represented by its Karta Kusum More. Kusum More. And second defendant is Kusum More. Then, my lord, the declaration what relief is sought for. Relief is that, my lord, a declaration that the terms and conditions relating to the period of tenancy, enhancement of the rent after 3 years at the time of renewal as mentioned in clause 1 of the tenancy agreement dated 1/4/2008, the terms and conditions relating to the termination of the tenancy as mentioned in clause 6 of the tenancy agreement, and the terms and conditions relating to the payment of the rent filed bank check obtaining a receipt mentioned in clause 12 of the tenancy agreement, then declaration that the advocate notice issued by the Kusum on behalf of Kusum or is unauthorized, declaration that plaintiff is being a lawful tenant. This is important, my lord. Plaintiff being the lawful tenant under the defendant cannot be evicted arbitrarily by use of force from the scheduled premises. That is, my lord, prayer, and that prayer was granted by the trial court, my lord. These are the documents, my lord. Plaint as well as the judgment. And I have got the original certified copy also, my lord, but not at the moment, my lord. I can.
that is not required. Okay.
So in that view of the matter, my lord, that plea which now they are raising cannot be tenable, my lord. And secondly, my lord, secondly, my lord, my learned brother has submitted that the plea was specifically taken in WR. No issue was framed. That is not correct, man. Issue was framed regarding maintainability. No specific plea was taken. No evidence was recorded. I have just found to your lordship, my lord. So that part of the submission is not correct, my lord. Thereafter, my lord, he says that the person has not come to the witness box, my lord. Upon that, my lord, I have some submission. The person who's come in the witness box, my lord, is not only an authorized representative of Kusum More, my lord, he also the member of the HUF, my lord. So whether the member of the HUF has no right to give evidence, my lord? Abhishek More. And he said that person
No, where is that statement that
yes,
he is the member of the HUF?
yes, that is there.
In your plaint, you have not stated
No,
who constitute that, who are the
no,
co-personers.
that is, my lord, in the evidence, my lord. In my affidavit in opposition, my lord, I have filed. affidavit in opposition at annexure A. It is the evidence on affidavit of Abhishek Moore,
Page number.
page number 1. Page number 1,
Wait.
para 1. Affidavit in opposition, page 6, my lord, annexure A.
Yes, what have you
Para,
said?
para 1, I have stated, I am the son of plaintiff number 2 in the above case, and plaintiff number 1 is the Hindu undivided family represented by my mother as the Karta of the family. I being one of the members in the family, plaintiff number 1, and entitled to depose in this case.
As co-personer, you have,
Yes, as co-person.
okay.
So, my lord, that part of the submission, that plaintiff has not come to the witness box, so suit cannot be proceeded, or the evidence cannot be taken into account, that cannot be taken, my lord. Then, my lord, here he has made the statement that in support of some affidavit, he has stated that the Abhishek Moore,
You stay in Bombay.
yes, he is Bombay, and for him only the suit was filed for bona fide requirement. That is absolutely incorrect. Let us see the plaintiff. Again, I am referring plaintiff at page 27.
Yes.
So, bona fide requirement was sought for. It specifically in para 4 of the plaintiff, para 3 and 4. It may be pertinent to mention here that plaintiff have their soap room on the ground floor of one-storied house bearing holding number 9 of GMC number 29 facing roadside Kedar Road, and out of that said 2 soap room, one being the suit premises, was let out to the defendant on the basis of the agreement as aforementioned, and in the soap room to the northern side of the suit premises, the plaintiff number 2 has been running the wholesale business of potatoes and onion in the name of KC Enterprise. Plaintiff have been residing on the upper story of the said house. It may be further stated that suit premises was let out to the defendant for a period only for 3 years, reserving the scope of getting back the suit premises by the plaintiff for the purpose of use, and the same is in future in expansion of their business. The defendant, being well known to the plaintiff, also agreed to vacate the premises in case the plaintiff required the space for their own use and occupation after the 3 years. Upon such mutual understanding, the suit premises were let out to defendant on execution of the aforementioned premises. That since some past, the business volume of the plaintiff has been witnessed significant growth, and for which the plaintiff requires more space to keep their merchandise. As the plaintiff has a good relationship with the defendant, so the beginning of the year 2011, the plaintiff made verbal request to defendant to vacate the premises upon expiration of the period of tenancy, but the defendant, instead of giving clear reply, avoided the request of one after another. So, my lord, it is not that I have made any statement that the suit premises will be required for the use of the business of my son. No,
Yes.
it has been stated
For the business of HUF.
for the business of the HUF. And my mother, she has been running the business, my lord. And in the defendant in the written statement, my lord, they have admitted it. That I have no sufficient space, my business is expanding. That part of all they have admitted, my lord. I am referring their written statement. Para 10 of their written statement at page 40. Page 40. Paragraph 10.
Yes.
As regards the statement made in para 5 of the claims, the same are not required,
Dhiraj.
same are not correct, and are not admitted. It is stated that plaintiff had sufficient place for their business.
Yes.
They have stated, my lord, it is stated that the plaintiff have sufficient place for their business and also for expansion of their business and to keep their merchandise. From the, my lord, from this his statement, it appears that I need the premises for expansion of my business because expansion is admitted. And second part, that I have sufficient place, they have admitted. But in evidence, my lord, when I put the cross-examination, where is that sufficient space? They say that it is only on the veranda. Veranda is the only sufficient space, my lord. In evidence portion, I will show, my lord. And expansion in evidence also they have admitted that I need the premises for expansion. So both the court, so finding the clear admission of the defendant, particularly in the matter of bona fide requirement, found that the plaintiff had requirement of the premises for his own use. Now that only that one line I will show, my lord, where they have admitted. Here. That is again in my affidavit in opposition, my lord, at page 44.
Page 44.
Page 44, I'm reading. Tenth line from the top.
Yes.
The plaintiff has her potato and onion business in the soap rooms, which is situated adjacent to the suit premises. Plaintiff used to sell the potato and onion in the electronic weighing machine, and that weighing machine is used to be kept in the veranda of the soap premises of the plaintiff. The veranda is open, so the machines was used to be taken in the soap while the soap was closed. I do not know why the weighing machine was kept on the veranda. The plaintiff used to keep her merchandise in the veranda, and the said merchandise used to be taken in the soap premises of the plaintiff when the soap was closed. It is not a fact that plaintiff used to keep the merchandise and weighing machine on the veranda because of insufficiency of business space in the soap. By suitable premises, again it is repeated, by suitable premises, I mean the veranda of the plaintiff's soap. That is the suitable premises, which he has stated in the written statement line. I had not mentioned the details of the suitable premises of the plaintiff for running of their business, and to my knowledge, veranda is the only place.
Okay.
So This is so far the bona fide requirement. Now, upon the defaulter point. For defaulter bylaw, in plaint, I have stated plaint, my lord, there are two at page 28.
Yes.
There are two. I have taken the defendant is a tenant under the plaintiff in respect of the food premises. The tenancy in the with the defendant was commenced upon the execution of the tenancy agreement dated first day of the April 2008 for a period of 3 years at a monthly rate of so between the plaintiff and defendant. The tenancy agreement contained various terms and conditions for the purpose of adjudication of the present food. The relevant terms and conditions are mentioned in so. Tenancy shall be deemed to have commenced from the first day of April 2008 for a period of 3 years, after which the landlord may extend the tenancy upon execution of fresh tenancy agreement and upon increment of the monthly rent at the rate of 15%. Monthly rent of the food premises was 5321 and the same was payable in the first week of the following month. That is important, my lord. I will come to that point again. In the first week of the following month, as per the English calendar month, by the tenant to the landlord against the valid receipt. Either of the parties shall be at liberty to terminate. That is not required. Now, then regarding defaulter, I have stated in para 8 that defendant has not only illegally enjoyed the possession of the premises even after expiration of the tenancy, but also defendant has not been paying any rent to the plaintiff since 1/4/2011 and became defaulter in the eyes of law, not entitled to any protection and rejection the provision of under control. Now, in return statement, what he has replied matters. Here, the admitted part of this suit is that relationship admitted, quantum of rent admitted, payment of rent, how it was to be paid, that also admitted. Now, what disputed is that, Your Honor, Your Lordship, I will show. He has given the reply of para 8 in the plaint is a para 13 in return statement.
Yes.
Para 13, para 2. Or in para 13 also may be required. As regards the statement made in para 8 of the plan, the same is incorrect and hence not admitted. It is stated that since the date of creation of tenancy in respect of the food premises, defendant has not violated the tenancy condition, paid the up-to-date rent to the landlord, plaintiff till the month of March 2011. The rent for the month of March 2011 was given to the plaintiff in the month of March itself. On the request of the plaintiff and also for the convenience of the defendant once again requested the plaintiff to allow the defendant to be in occupation of the tenanted premises, but the plaintiff refused to listen the defendant. and once again ask the defendant to vacate the premises. Now, next para, the defendant further states that on account of institution of the title suit number 133 of 2011, that suit he brought against me, as well as on account of issuance of the above said advocate's notice by the plaintiff number 2 on the defendant, the non-compliance of the notice by the defendant, the plaintiff did not come to the defendant for collection of the rent for the month of April 2011 till 2/5/2011. This is important, my lord. This may be underlined. As such, the defendant himself went to the plaintiff on 3/5/2011 and offered rent for the month of April 2011 at the enhanced rent of the monthly rent amounting to the sum of rupees so and so rounded to 6120 by check number 103461 dated 3/5/2011 drawn on Oriental Bank of Commerce following plaintiff and requested the plaintiff to inform the defendant about the electric charges. Now here the question, the important thing is that he said that the plaintiff did not come to collect the rent. First of all, plaintiff never went to collect the rent, but he made the statement like that. Then he said that up to 2/5, the plaintiff did not come to him. Then on 3/5, he went to the plaintiff to offer the rent. Now, let us see his evidence portion in that regard. Yes, cross-examination. Cross-examination starts from page 43 of my affidavit.
Yes.
Here, he said that in page 1, there was no agreement with the landlord to receive the rent per month. It is not a fact that I had not offered any rent to the plaintiff prior to deposit of the rent in the court. I started depositing rent since April 2011. Next page, I offered the rent. I offered the rent for the month of April 2011 to the landlord on first day of April itself, my lord. My lord, the rent for the month of April was to be offered on the following month. It must be May. But he says that I offered the rent for the month of April 2011 to the landlord on the first day of April itself. That cannot be a valid offer. Thereafter, my lord, I do not remember if any proof is submitted in respect of my offer of rent to the landlord for the month of April 2011. I do not know if I had submitted the check number so-and-so in the instances. Now, he has stated in a statement that I offered the rent by check, my lord. He could have produced the check, my lord. If actually the rent was offered by check, my lord. But neither the check was exhibited, my lord, nor even cross-examination. He did not produce the check, my lord. And then he admitted that rent was offered in first week of April. So in all view of the matter, there was no offer of rent, my lord. Thereafter, my lord, it is not a fact that I did not have any check bearing number so-and-so, so I did not deposit in the present case. It is not a fact that as I did not offer the rent for the month of April 2011 to the plaintiff, so I could not give the details of time, place, and presence of my person at the time of such offer. It is not a fact that I did not offer the rent to the subsequent month after April to the plaintiff, and so I did not give the details of the time, place, and presence of the witness. It is not a fact that I did not offer the rent for the month of April within its due time. I used to make the payment.
Okay, your submission is that there was no valid offer.
No offer is there, my lord. Now, besides that, my lord, what NJ cases which he has exhibited, my learned brother says that he filed the application for calling of the record, it was not allowed, is not factually correct, my lord. The records were called for. Thereafter, my lord, for subsequent records, there may be prayer for calling of the subsequent record that may be refused, but who prevented him to go to challenge this action of the court, trial court?
Okay.
Yeah, my lord, that upon that, my lord, very important that regarding the process fee, specific question is there, my lord. I am coming to that.
No, that is admitted that he did not take steps for.
Yes, he admitted it. And then by NJ case records, I put the question whether there is a process fee, whether there is a notice. He said no. And that record also was exhibited. So from record itself appears no process fee, no notice, nothing was submitted, and no offer was also there.
Okay.
So it is clear case of a defaulter manner. That apart, bona fide requirement is also been proved, my lord. So there is a concurrent finding on both the issues, my lord. And regarding that, my lord, truth was untenable, so it was never disputed.
Still.
And regarding
Enough.
some other. And regarding Bombay, my lord, affidavit which my lord Mr. Brother said, already I given reply that Abhishek is now working in Bombay. So bona fide requirement, I given reply. Since beginning, the business is being run by my mother and she is still been running. I have submitted along with the affidavit, the income tax records, my lord. This shows that I am running the business, man, in my affidavit. In my affidavit, in reply, your lordship will find annexure A and annexure B.
Okay.
Annexure A is the income tax return, my lord. And this return is the name of Kusum More, my lord. That business is running by my mother, my lord. And she has been running after the death of my father, my lord. And thereafter the municipal license, my lord, it has been renewed. That it is a running concern. It's not that I shifted there and the business has been closed and there is no requirement. It is factually incorrect now. And so far, some plea is taken that I filed a document after settlement of issue. This all are unnecessary. This some plea is to be taken that way is taken, my
But
lord.
what is your response?
No, my lord, that is not the there, my lord. The document were filed at the time when the document wished to be filed. That is not correct. I am denying that. And regarding that certified copy, my lord, I can produce by tomorrow, my lord.
Any reply, Mr. Roy?
Lordship, my learned friend has not submitted before Lordship regarding the concept of the HU conversion to partition. Here, Lordship, the original Karta was Vijay Kumar Moore, husband of Kusum.
No, but where is that details of who constitute the
In the
HUF?
plan, no, nothing has been given. Apart
They have
from-
not stated anything.
Yeah. Lordship, when the property, earlier Karta was Vijay Kumar Moore, husband of the wife. After his death, his wife will be entitled to inherit only half share. And son will inherit half share. So that will be as per the law of inheritance. But here, the suit has been filed in the name of the HUF lordship represented by the lady.
But the son was also one of the co-personer. He said,
There is no averment.
he said in his,
He is not a party, there is no averment in the plaint. He has, in the plaint averment is that he is also one of the member of the family. That is the averment, what my learned friend is before your law. There is no word in the plaint regarding that he is the co-person. Apart from that, my learned friend has submitted that there are evidences that Abhishek Moore, minor at that time. Your lordship may please to come to the take up the affidavit in opposition filed by my learned friend. This affidavit in opposition, evidence on affidavit that your lordship in the affidavit in opposition at page 6, your lordship will find the evidence on affidavit of Abhishek Moore, which was he filed in 2000. Lordship may come to page 11, affidavit verification portion lordship. This was filed on 9th of October 2013. Page, and the suit is of 2012 lordship. So they believe that he was a minor, Abhishek Moore.
what was his age at that time? 9 October 2013.
22 years. First line, I, Sri Abhishek Moore, son of late Vijay Kumar Moore, aged about 22 years. But my learned friend has submitted that that time he was
I'm saying is
minor.
that
My
at the
learned
time
friend,
when the
when
agreement-
you are arguing, I did
No,
not utter a single word.
I'm just making it.
Let me
correct.
place.
I'm just making it
You will
correct.
get your opportunity to
Again, I
clarify.
have to give the reply then.
Honorable court will give you ample opportunity, don't worry. This is one aspect of the matter. And only both the courts below come to the finding that April 2011 rent deposit was made, but the notice, sending notice to the landlady was not taken a step. So regarding that, your lordship evidence here. Abhishek. Cross examination of the PW1 Abhishek Moore. Cross examination is available at page 12 of the affidavit in opposition.
Yes.
From the bottom lordship, on 19/6/12, the list of the witnesses of the plaintiff was filed there in the names of the witnesses were mentioned, but my name was not mentioned in the list. Apart from that, no permission was sought, next line, from the court by me for depositing on behalf of the plaintiff. Then it will First, your lordship may please to come to page 15. Page 15 on the top.
Yes.
Line 4. However, I admit that the rent upon the period March 2011 was received from dependent by my mother as Karta. Then next line your lordship at the bottom. Contradictory statement. I have no knowledge if the defendant has demonstrated in the court for the month of April 2008 and onwards, and if he is continuing to deposit the rent in the court till now. So Lordship, only the sole witness PW1 says that he has no knowledge regarding the deposit of the rents and nothing. Then Your Honor, when from the learned courts below come to a finding on what basis that the petitioner is a defaulter? See the perversity writ large on the face of the record. There is
No, he had no knowledge because no notice was issued.
notice was not given only in respect of the one of the NJ case, Lordship, not in all. In my WS, and apart from that, Lordship, there is no evidence. Pleading must be supported by oral evidence, that is well settled law. Everybody knows. So where the pleading says that there was a default in April 2011, the cross-examination, the PW1 deposits that he was no knowledge if the defendant deposited the rent in court for the month of April and onward, and if he continued to deposit the rent in the court till now. So what will be the presumption, Lordship? There is pleading was not supported by the oral evidence. And both the courts below gave the finding that the tenant is a, apart from that, Your Lordship may be pleased to peruse the WS. All through the tenancy period, the rent were paid together. I have shown only two paras. Now Your Lordship may be pleased to come to step para.
Reply should only be based on the technical, low point matter. If in this way, then I have also to give
Mr.
the reply.
Sharma, I never interrupted.
Already
I
has
did not
stated
utter a single
elaborately, my
word
lord.
when you were submitting.
No, that you have already made submission.
No, just other, just 1 minute. Lordship, will be pleased to come to page 38, part of the W. Page 38. Page 38, Your Lordship, from para Roman 2 to onwards, all the rents were taken by the plaintiff, Your Lordship. If for 2 months, 3 months, 4 months, you're all.
That you have submitted.
Earlier I had shown only 2 entries. Now next page also, Lordship. So there was no due date, Lordship, apart from that. And the citation submitted by learned friend on the concept of the HUF is not relevant at all. The Supreme Court judgment is very clear. Another judgment I would like to cite on the same point of the apex court. And my learned friend, para 14, where the apex court held that there cannot be a HUF or consisting of only females lots. Para 11, very clear cut judgment.
That's
2001 SCC.
That is not in the tenancy.
I don't know how much.
2001 SSC or आगे बढ़िए.
बोल दो, that is enough.
Yes.
Yes. Regarding my learned friend had submitted that this point was not raised. The issue was framed. The learned trial court in its finding given that this point was raised, but it was not argued. What is this, Lordship? If the point was raised, this is a pure question of law, Your Lordship. And in this respect, even if this plea is not taken in the WS, Lordship, then the court is bound to take. Then, Lordship, I am relying on a Supreme Court decision reported in 2011 6 SCC 386 para Lordship 40. At any stage of the proceeding, before any court, it can be raised.
What?
Regarding maintainability, point of law, para 40. There is no quarrel to the settled legal proposition that a new plea cannot be taken in respect of any factual controversy whatsoever. However, a new ground raising a pure legal issue for which no inquiry proof is required can be permitted to be raised by the court at any stage of the proceeding. See this is the clear-cut judgment, Lordship. Though in the WS Lordship, even in the WS Your Lordship, plea has been taken by the petitioner defendant that the plaintiff number 2 Kusumor is not the landlady of the defendant that Your Lordship will find in WS Lordship.
Okay.
So, yes.
You yourself, you have brought the suit, now you are saying there is no.
Yeah, brought us this it, whether
You brought the declaration
I have
that you are the
I have-
tenant under her.
that is entirely my electricity connection was
You
disconnected.
cannot.
Attempt was made to throw out. That's
Approbate
why
and
I
reprobate
filed
at the
this suit.
same time, your honor.
That admission
That
will not
cannot
be
be
allowed.
allowed.
No,
My
let you,
learned friend is in habit of the interpreting.
let-
I never uttered a single word while you.
let your clients fight. Why are you fighting?
No, we are good friends, my lord, we are not fighting.
You are showing your friendships. Heard
The
Mr.
court, not in the.
Heard Mr. S.P. Roy, learned counsel for the
My lord, one thing I.
petitioner.
Clear, my lord.
Yes.
ACR will be required.
No, my lord, factually it is incorrect, my lord. He has said that Abhishek Moore was adult at the time, my lord. What I have stated, that when the agreement was executed, Abhishek Moore was minor, my lord. The agreement was executed in 2008. I have got the certificate, birth certificate of Abhishek Moore, my lord. And birth certificate.
No, but his plea is of filing of the
So
suit.
he has shown from the affidavit, my lord, that age, my lord.
Yes,
to
at
that
the,
matter.
at the time of filing of the suit.
Yes, filing of the suit, that is not different, my lord. But when the agreement was executed in
He was
2008,
minor.
He
was
could have done a minor, he could have been implemented as the plaintiff number 3, Your Honor,
Yeah.
and being
But by
represented
that
by
time-
his natural father and guardian, Kusum Moore. Where is that in
by
the
that
plain?
time, the judgment has come from his side, my lord. That is the tenant.
Heard Mr. S.P. Roy, learned counsel for the petitioner. Also heard Mr. J. Sharma, learned counsel for the respondent. This civil division petition has been registered on filing of an application under Section 115 of the Code of Civil Procedure 1908 by the predecessor in interest of the present petitioners, namely Raichand Bagaria. He died during the pendency of this,
Suit.
the suit or this revision petition.
Revision.
Division petition. During division petition. Division petition, my lord. Division petition. pending, my lord.
During pendency of the CRP law.
It is pertinent to mention herein that during the pendency of this instant revision petition, the original petitioner, namely Raichand Bararia, had expired, and thereafter his legal heirs, the present petitioners, were substituted in his place. In this revision petition, the judgment and order dated 1910 to judgment and decree dated 1910-2015 passed by the Court of Learned Additional District Judge number 1 Kamrup Metro in title appeal number 79/2015 has been impugned. by the said judgment, the first appellate court has upheld the judgment and decree dated Wo- wo- no, what is the date of the appellate court judgment?
Argument.
But date of judgment is 39/2016.
Yes.
Change that date. Change the, read first. Not by this judgment, the impugned judgment. फिर से पढ़िए पैराग्राफ. No, in this judgment and decree dated 39/2016, passed by the Court of London, Additional District Judge Number 1, Kamrup Metro, entitled Appeal Number 79/2015, has been impugned. By the aforesaid judgment, the First Appellate Court has upheld the judgment and decree dated 19/10/2015, passed by the Court of London, Munsif Number 1, Kamrup Metro, entitled Suit Number 37/2012, whereby the suit filed by the present respondents for eviction of the predecessor in interest of the eviction of the present petitioner from the suit premises was decreed on the ground of bona fide requirement as well as on the ground of defaulter in payment of rent of the suit premises. The facts relevant for next para, the facts relevant for consideration of the instant revision petition, in brief, are that the present respondents, namely Messrs. Kishorilal Vijay Kumar, a Hindu undivided family represented by respondent number 2, Srimati Kusum Moore, as its Karta, had filed a suit for eviction of the defendant Raichand Bararia on the ground of defaulter in payment of rent as well as for bona fide requirement. The said suit was registered as title suit number 37/2012. Stop. It was contended in the plaint by the present respondents that the plaintiff number 1, that is the Hindu undivided family, is the Hindu undivided family, Messrs. Kishorilal Vijay Kumar, is the absolute owner of a shop room measuring 450 square feet, situated in ward number 29 of Gauhati Municipal Corporation, at Kedar Road, Gauhati, with holding number 9. The said suit premises was let out on rent to the present petitioners by executing tenancy agreement on 1st of April 2008 for a period of 3 years at a monthly rent of rupees 5,321. In the plaint filed by the present respondents before the trial court, it was contended that this suit premises was required by the present respondents for expansion of their own business, and therefore on the ground of bona fide requirement, the eviction of the present petitioners was sought for. It was also contended that the present petitioners defaulted in payment of rent since 1/4/2011, and on that ground also the eviction of the present petitioners was sought for. The present petitioner contested the suit by filing written statement wherein it took usual defense like that of non-maintainability of the suit, absence of cause of action, and other general defenses. It also denied that the present petitioner has defaulted in payment of rent. As well as also denied the plea of bona fide requirement by the present respondents. On the basis of pleadings of both the parties, the trial court framed following issues. Court issues from page 52 and 53 of this from the petition. In support of its in support of the contentions made by the plaintiff in the suit the son of present respondent number 2, namely Abhishek Moore, was examined as PW1 by the plaintiff, and 10 documentary evidence were exhibited by the plaintiff side. On the other hand, defendant Raichand Bararia examined himself as DW1 and exhibited certain documents, including some records of missed non-judicial cases before the trial court. However, ultimately, the trial court, that is the Court of Learned Munsif number 1, Kamrup Metro, by its judgment dated 19 October 2015, decided all the issues in favor of the present respondents and held the present petitioner as defaulter in payment of rent, and also held that the suit premises is required bona fide by the present respondents, and accordingly decreed the suit against the present petitioners. Being aggrieved by the being aggrieved by the judgment of the trial court, the present petitioner preferred an appeal before the Court of Learned, Additional District Judge number 1, Kamrup Metro. Stop. The said appeal was registered as title appeal number 79/2015. In the stop. However, the appeal was also decided against the present petitioners by the appellate court by its judgment dated 30/9/2016. And this revision petition is filed before this court, impugning the aforesaid judgment of the first appellate court. Mr. S.P. Roy, learned counsel for the petitioner, has submitted that both the trial court as well as the appellate court erred in not taking into consideration the fact that though a plea of maintainability was raised by the present petitioner in the written statement filed by them, filed by him, and though the tenancy as regards the suit premises was in between the present petitioner as well as Messrs. Kishorilal Vijay Kumar, which is a Hindu undivided family. However, the courts below failed to take into consideration that it was not represented by proper person in the suit filed before the trial court. He submits that a female Hindu cannot be a karta of a Hindu undivided family, as has been shown in the plaint filed by the present respondents before the trial court. He submits that the though the son of late Kishorilal Vijay Kumar was an adult at the time when the suit was filed. However, he was not made a party in the suit filed by the present respondent. He submits that even after which one was the judgment? He further submits that
2015, 16 SCC, page 46. Party are Sidia Vidyarthi versus Ashok Vidyarthi.
he submits that even after amendment of the Hindu Succession Act 1956 in the year 2005, only a daughter can be regarded as daughter has a right to be treated as a co-parsoner. However, in the instant case, the Srimati Kusum Maur was the wife of Kishori Lal, wife of late Vijay Kumar. She was widow of the late Vijay Kumar, and she cannot be regarded as a co-parsoner in the Messrs. Kishorilal Vijay Kumar HUF. Hence, filing of suit by the HUF showing Srimati Kusum Maur as its karta is a defective filing and same is not maintainable. In support of his submission, he has cited the ruling of the apex court in the case of Shreya Vidyarthi versus Ashok Vidyarthi and others, reported in 2015 16 SCC 46. He further submits that though Srimati Kusumor was made as plaintiff number 2 by name in the aforesaid suit. However, she never deposed before the trial court as a witness in the said suit, and therefore a presumption would arise that the case set up in the plaint by the plaintiff is not correct. Mr. S.P. Roy, the learned counsel for the petitioner, further submits that if a party abstains from entering into witness box, it would give rise to an inference adverse against such an party, and the plea taken by such a party, suppose, stop. He, in support of his submission, he has cited following rulings. Number 1, Man Kaur within bracket dead by LRS. LRS versus Hartar Singh Sangha, reported in 2010 10 ECC 512. Number 2, Vidyadhar versus Manik Rao and others, reported in 1999 3 SCC 573. He submits that the sole witness examined by the plaintiff in this case is the son of the plaintiff Kusumor. However, he was not authorized by the. What was your submission? He was not. He was not authorized by the HUF to depose on its behalf, as the said witness failed to show any such authority. He further submits that the suit premises was not. He further submits that it was the contention of the plaintiff before the trial court that the suit premises was required by the son of plaintiff number 2 for the purpose of expanding his business. However, during the pendency of the litigation between parties, it came to the notice of the petitioners that the son of the plaintiff number 1 has petitioner number 2, son of plaintiff number 2, Srimati Kusum Moore, namely Shri Abhishek Moore, has where is that?
Additional affidavit by the petitioner dated 8/5/24. I have submitted, mentioned para 7, 8. And 10, and annexure is also filed showing that he is serving in Mumbai. That annexure is page 117.
Yes. Dot. I have taken note. I will continue dictation. I am reserving the judgment.
I have submitted the 2 more judgment on the point that the documents were not filed before settlement of the issue. And LCR has not.
Dot लिखा हो. Learned counsel for the petitioner has also submitted that the trial court as well as the appellate court also failed to take the fact into consideration that documents submitted by the plaintiff, that is the present respondents before the trial court, were not submitted at proper stage. He submits that same were submitted after framing of issues. However, no leave for doing so was taken by the plaintiff. He submits that on this count also the
Documents filed by the plaintiffs are inadmissible.
the documents filed by the plaintiff cannot be relied upon by the trial court. However, said fact has not been taken into consideration by the trial court, neither same was taken into consideration by the first appellate court.
This part of the statement, I am denying my lord.
Yes, I have taken note.
That's why trial court record is required also to verify.
I'll continue. I have taken notes. It will take time. Heard Mr. S.P. Roy, learned counsel for the petitioner, also heard Mr. J. Sharma, learned counsel for the respondent. Hearing concluded, judgment reserved.
Obliged.
I would like to vote for item number 15.
Just a minute. Wait for a minute. Ramesh, the judgment will have separate file बनाए रखे. Yes, Miss Hajarika.
Some personal information for item number 15 by senior has been used for her case.
Item number?
Yeah, for respondents, national insurance.
Item number 15. Who is for the other side? Heard Miss, what is her name? Hesboro Learned Counsel for the appellant. Also heard Miss D. Hajarika, Learned Counsel for the respondent, who submits that due to some urgency, Learned Counsel for the respondent had to leave the court, and on that ground she prays for an adjournment. The prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
Should say
14. 14. Same order. Who is for the other side? 14 also same order. Other side apps. Okay. Just call the next head.
Upgraded at 10:16.
Claims still on order of the motor accident, sorry, the railway accident claims tribunal. It was passed with single judgment, member technical. I mean, Lord, there is a judgment of this honorable court. In fact, there are two others also. They've been relied upon here. Lord, it has to be taken by the division bench. There are more than two members at this moment.
Judgments have been referred out here, but there are more judgments. It says that a single bench of the tribunal cannot decide.
Staple করিব, huh?
Look,
Even there are judgments, but the lordships smell on the same issue. I'll let a friend his hand. There's several months, 89 days ago. You don't know.
Heard Mr. M. Datta, Learned Senior Counsel, assisted by Mr.
Elden.
L.
Deca.
Deka, Learned Counsel for the appellant. Also heard Mr. B. Sharma, Learned Standing Counsel, NF Railway, appearing for the respondent. This appeal under section 23 within bracket 1 of the Railway Accident Claims Railway Claims Tribunal Act 1987 has been preferred by the appellant Srimati Aarti Pal Chaudhary, impugning the judgment and order dated 22/5/2019 passed by the Railway Claims Tribunal, Gauhati bench in claim application number OA Roman capital Roman 2 small u dash 43/2017 old. Stop. What was held by the impugned?
My case was dismissed, well, saying that.
Whereby the claim for compensation filed by the present appellant was rejected. It is submitted at bar that the impugned judgment in this case, no, it is submitted by Learned senior counsel for the appellant that the impugned judgment in the instant case has been delivered by only single, only member technical of Railway Claims Tribunal sitting singly. However, there is no indication as to whether any authorization for same was under what rule authorization is there.
For section, 4 subsection.
Subsection 4 of section 4.
Where is my judgment? However, Kalika was granted under section 4 within bracket 4 of the Railway Claims Tribunal Act in this regard. He also submits that the judgment of the Railway Tribunal, Claims Tribunal has to be delivered by division two, has to be delivered by a bench of 2 members in terms of, say, the provisions contained in section 4 within bracket 2 of the Railway Claims Tribunal Act 1987, and only deviation in that regard may be done if authorization under subsection 4 of section 4 is given by the chairman to any member to take up the matter sitting singly. And as in the instant case, no such authorization was there, the impugned judgment is liable to set aside on that ground only, and it is liable to remand it back to the Railway Claims Tribunal for deciding the matter afresh. After complying with the provisions of the Railway Claims Tribunal Act 1987. Is it okay? Anything?
Now, after these judgment, my lord, even if there is an authority that has to go, because this judgment doesn't distinguish between authority and no authority. Anyway, it's correct.
Since Lordship is remanding back the matter, there's nothing remains. Lordship only fix a time frame. So
Mr. B. Sharma, Learned Standing Council, also agrees to the submissions made by Learned Senior Counsel for the appellant and submits that the matter may be remanded back. Stop. Since the Railway Claims Tribunal Act clearly provides for the contingency in which a single member of Railway Claims Tribunal can, no, you take a quote para 12 para 12 from MFA number 38/2013. Since this is a very old pending matter of the year to not way 2017, the Railway Claims Tribunal Gauhati bench is directed to dispose of the matter as expeditiously as possible, preferably within a period of 6 months from the date of receipt of copy of this judgment. The registry shall immediately send back the records of the original application requisition in connection with this appeal, along with a copy of this judgment to the Railway Claims Tribunal for compliance. This appeal is accordingly disposed of.
Not with regard to this.
Okay.
Item number 31, which is listed for orders today, Lordship has posted it after 4 weeks, my lord. I was not there when the matter was called up, my lord. That matter is also exactly similar, my lord. My friend is there, passed by a single,
I'm appealing for the other side.
single.
My lord, already has already been passed after 4 weeks, my lord.
And this is-
Similar order may be passed after 4 weeks, my lord.
Unnecessarily keeping it pending. I don't know why is it.
Already has been passed, my lord. I am not carrying the file. I have written the.
In the morning,
Item number 31, I could not remain present because I was in some other.
Not mentioning, my lord. It was called.
okay, then wait for 4 weeks. Otherwise, we have to recall many such orders.
Item 12. My lord, in item 12, I am the respondent before my learned senior client submit. The law is going against me, my lord. Again, it's a technical member judgment. Matter may be remanded back to the jury.
My lord, this is the old pending case from the year 2015, my lord. My lord, in this case, earlier, my lord,
Shh. Go record to
learned RCT,
a judgment. To
the main practice, my lord, this is the case of the shortage, claiming of the compensation on account of the shortage and damage of the consignment. So earlier, the single member of the RCT passed this order dated 16/8/2010, which was challenged under before this honorable court, MFA number 296 of 2010. Then honorable court filed order dated 1/4/2014, remanded back the matter to the RCT or to decide the matter on merits, my lord. Then after incomplete of the order passed by the honorable court, my lord, RC dispose of this way.
again by
Single member, my lord. So, single member. And this judgment has been challenged with the honorable court.
But what will happen to 4(2), section 4(2) of the, which says that it should be by a division bench?
My lord, so
My lord, it's going in their favor, in fact, my lord. The law is in their favor.
they are afraid of that the case is going in our favor, the pendulum is swinging in our favor. So they are not entitled to get any compensation for shortage debits. There's a big argument, my lord. Along with the large number of decisions passed by the honorable court, my lord. In similar case, my lord, large number of decisions has been passed by the honorable court in favor of me, my lord. So, my lord, this case also, this judgment also passed by the single members, my lord.
No, but when the matter is pointed out to this court that there is a jurisdictional error, single bench.
See, recently this order has been passed, my lord. Matter may be referred to the division bench, my lord. But this is a earliest order. So this.
That earlier order will stand.
My lord, there are 5-6 judgments, my lord, argued by me only.
My lord, twice the single member passed this judgment, my lord. One earlier is to challenge before the honorable court,
No, there is no bar in passing the judgment by the single bench, single member, provided there is an authorization.
Yes,
Yes, my lord.
subsection 4.
Yes. If there is no authorization, then this is not a.
Was was not raised earlier, my lord. When the right, the.
But jurisdictional fact can be raised at any time.
In fact, my lord, I am raising it. It should be raised by the railways, my lord, this ground.
Or what do you want, Ms. Chakravarti?
If lordship permit me, then I want to conduct a hearing on the basis of the judgment of single bench, the technical member.
No, you make your submission on this point, whether judgment by a bench constituting only the technical member is maintainable or not.
But earlier, my lord, when the technical member passed the judgment, this was challenged before the honorable court. This question, this jurisdiction error was not raised, my lord. The honorable court had order dated 1/4/2014 remanded back the matter before the RCT, and then RCT, in completion of the High Court's order, my lord, RCT passed the judgment 13/3/2015, which was passed by the technical member, the single member. In number of cases, my lord, the RCT passed the judgment by the technical member, and which was already entertained by the honorable court, but the respondent also had not raised any objection regarding the jurisdictional error, my lord, with it under section 4(2), my lord.
My lord, there's this one.
Now they are raising the money. It will be a consumption of the time, my lord.
But suppose the bench does not have jurisdiction.
Yes, in other cases also, my lord, is also pending before the honorable court. The railway board chairman, the RCT chairman already directed the RCT. When number of cases are pending before the RCT, no judicial member is there. So technical member is allowed to.
That authorization is there or not.
His authorization is there, my lord.
But in this case,
This question was not raised, my lord.
then unless authorization is there.
It is unless authorized, no. The judicial error was not raised earlier also, not now also. Now it is up to lordship, my lord.
My lord, there's this one submission, my lord. In respect to a single member can adjudicate, my lord. I am totally in agreement with the fact that a single member can adjudicate the matters singly, my lord. However, my lord, it cannot be done by a technical member. It can only be done by a judicial member, my lord. Because, my lord, the interpretation of the law and statute has to be derived, my lord. Without interpreting the law, a technical member is merely an administrative member.
Yes.
When the respondent being applicant, when challenging these actions of the railway for claiming some compensation, that time the respondent could have raised this objection before the RCT that you are not authorized to hear the matter. Division bench should be constituted. That point was not raised before the RCT. That's a technical member himself passed this order.
Miss U. Chakravarti, learned senior railway counsel appearing for the appellant. Also Mr. D. Rathi, learned counsel for the respondent. This appeal under section 23 of the Railway Claims Tribunal Act 1987 has been filed by the Union of India, impugning the judgment and order dated 13/3/2015, passed in original claim application number OA-1/GHY/2002/0035 by the Railway Claims Tribunal, Gauhati bench. Learned Senior Railway Council has submitted that on an earlier occasion also, the present appellant approached this court being aggrieved with the judgment and order dated 16/8/2010 passed by the Railway Claims Tribunal in the above mentioned original claim application. The said appeal was registered as MFA number 296/2010. Stop. However, after hearing both the sides, this court was pleased to remand back the matter to Railway Claims Tribunal for passing fresh judgment after affording adequate opportunity to both sides for leading evidence. She submits that in compliance with the aforesaid direction, the present appellant produced documentary evidence before the Railway Claims Tribunal. Stop. She, however, submits that no, before this, at the beginning, Likimo, at the inside, Mr. D. Rathi Lalit, counsel for the respondent, raised has pointed out that since in this case the impugned judgment was delivered by member technical Railway Claims Tribunal sitting singly, it is covered by the earlier judgment of this court in this regard, which has observed that unless an authorization under Section 4 within bracket 4 of the Railway Claims Tribunal Act is there, member technical cannot dispose of claim cases under Section 4(2) of the under Section 4 of the Railway Claims Tribunal Act 1987 sitting singly. उसके बाद मिस यू चक्रवर्ती, she, what was the last line earlier? Yes, she further submits that the point of jurisdictional error, point of lack of jurisdiction of the member technical sitting singly delivering the judgment in the instant case was not raised on the earlier occasion. She therefore submits that this appeal may be heard on merit. Stop. I have considered the submissions made by learned counsel for both sides. it appears that in the case of Union of India versus Messrs. Jain Enterprise, within bracket, MFA number 38/2013, and some of other cases, this court has already held, this court has already taken a view that 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 unless an authorization by the chairman, unless an authorization under section 4 within bracket 4 of Railway Claims Tribunal Act is there by the chairman of the Railway Claims Tribunal to any of the member to function as a bench consisting of a single member, the member technical cannot decide the claim cases filed under the aforesaid above mentioned act sitting singly. It also appears that in the instant case, no general or special order has been produced by the railway authorities in terms of section 4 within bracket 4 of the Railway Claims Tribunal Act 1987. Since in cases where facts were similar, since in earlier cases on similar facts, this court has remanded back the case to the Railway Claims Tribunal for complying with the provisions of Railway Claims Tribunal Act and to pass a fresh judgment. A different stance cannot be taken by this court in the instant case. As in the instant case also, the impugned judgment was passed by member technical of Railway Claims Tribunal, Gauhati, sitting singly. Quote para 12 again. MFA 13. Since this is also a very old pending case of the year 2002, the Railway Claims Tribunal Gauhati bench is directed to dispose of the matter as expeditiously as possible, preferably within 6 months from the date of receipt of the copy of this judgment. The registry shall immediately send back the records of the original application requisition in connection with this appeal, along with a copy of this judgment to the Railway Claims Tribunal, Gauhati bench for compliance. This appeal is accordingly disposed of.
My lord, this one issue, my lord, which we are facing right now currently because with learned railway claims tribunal. Because, my lord, there are a few matters which was remanded by the Honorable Gauhati High Court on the ground that technical member do not have power. However, subsequently, my lord, the learned technical member is still adjudicating those matters singly, my lord. One of those matter, my lord, one of the case, it has been reserved, my lord, on 11th May 2026. My lord, again, this matter will be remanded to the tribunal. Again, the technical member will adjudicate the case singly. Again, an appeal, same drill will go on, my lord.
No.
Some
Wow.
observation or something, my lord, some observation will be planned to the technical.
There is a way out. The statute itself gives. Chairman Railway Claims Tribunal can give authorization.
My lord, in fact, learned chairman of the Railway Claims Tribunal has granted authorization to the learned technical member. One of our client has only challenged this before the Honorable Gauhati High Court. I was arguing that matter, and Honorable Gauhati High Court, as an interim relief, has suspended that order, my lord. Still, the cases, learned technical member is adjudicating the cases, my lord. I have the review number, my lord. I'll just raise it before the lordship.
When there is an
Some strict observation, my lord. All I am seeking is some.
my lord, there is no judicial member. How the case will be pending for a long time. That's why they are authorizing the technical member to dispose of the case.
The High Court has suspended, my lord, and still the learned technical member is adjudicating. It will lead to multiplicity of litigation. That's it, my lord. Because again, I have to prefer an appeal. Again, the matter will be remanded to the tribunal. If some direction, strict direction, I'm not seeking it.
No, but that matter is not before us.
Yes, my lord. That's why, my lord,
That
I am
is
praying
not
because
clear.
some strict order may be given.
In that review petition, you have to make mention in which that authorization order has been suspended. In that case, you have to raise this issue that in spite of suspension of the order, it is still being continued.
That I'm
This court does.
that I'm not, I know, my lord.
But this
it's a
court
different
cannot.
matter. I'm not going into that, my lord. However, one of the matter which was remanded was also again adjudicated, my lord. That's why some observation, strict observation, that
No.
it may be constituted by division bench, my lord.
You have to file the case.
No.
Then that's that case.
Unless the review, it is a interim order only, suspension. The final order may go against you. Technical member may be ultimately be allowed to adjudicate in, suppose there is no judicial member and law provides that sitting singly, it does not discriminate between judicial member and technical member.
There is, my lord. My lord, as per section 21 of the Railway Claims Tribunal procedure, my lord, the interpretation of law and statute and question of law has to separately has to be framed, my lord. And there is a Gujarat High Court judgment passed by Honorable Justice Pardiwal.
This you argue before that court. Matter is already pending.
My lord.
So
I am obliged.
we are not passing any further order in this case.
Okay. Arjun 13.
But in 13 is also the same matter for the claiming compensation for shortage and delays, my lord. So there is a wrong argument will be there, my lord. I think it will be a appropriate matter to file written arguments and argue the matter.
Yes.
And for the sole respondent, my lord. My lord, I have also filed one written argument in this.
You have already filed.
No, lordship.
You will be filing. Heard Miss U. Chakraborty, learned counsel for the appellant. Also heard Miss what? M. Kolita, learned counsel for the respondent. It is submitted at bar that the counsels may be allowed to also file written gist of their respective arguments. The prayer is allowed. We are giving a date. Yes. Let this matter be listed. Give a date, Ramesh. When? You suggested it.
Last week. What? No, I'm not there. After vacation, maybe it will be gradual. After vacation,
23rd July.
23rd July, yes.
Of that children.
Item 20.
My friend was here, he was very anxious that this be done today.
Who?
That's I know.
What is his name?
He wanted to be, he was very eager about it. Anxious about it, and it be done today. Thought it may be given.
Oh, he has vanished.
Some,
Mr. Das, BK Das.
He even called me up yesterday, this morning, again. He was very serious. Maybe some problem, I said, in a short time, because he was very,
Heard Mr. R. Goswami, learned counsel for the appellant. None has appeared for the respondents on call. Let this matter be listed. On 24 July,
I think he has some urgency also, some. He was actually, he wanted to mention it at 2 p.m. in the morning for upgrading this engine. So I'm only trying to convey his anxiety also.
so what is to be done?
At the earliest possible date.
June. 12 June.
Sure, I'll tell him. Problem.
Item 21.
Who is for the others? Yes. Yes.
Can I start? Yes.
Who is coming? Who is the counsel? What is his name? Okay. Let him come. We'll take up some other item. Let him come. Next item. Yes.
Your Honor, my senior has to leave for urgently for a doctor's appointment. A date may kindly be fixed after vacation.
Yes, Miss Todi.
K. Bhattacharya Lodge.
K. Bhattacharya. Sorry.
For date may be fixed.
Heard Miss K. Bhattacharya, learned counsel for the appellant. Also heard Miss, what is her name?
Miss J. Hendick.
J. Hendick, learned counsel for the respondent, who submits that due to some medical urgency, the engaged counsel for the respondent had to leave court early, and therefore an adjournment is prayed on that ground. The prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
Item 26.
I forgot this for minutes. I was in the other, I had mentioned item number 20.
20 gone.
20,
20 we have given a very short date.
there is some urgency in this matter, like matters. The 22nd occasion matter has been listed for hearing, my lord. 2021 matter was not disposed of. And my lord,
Where is Mr. Goswami?
if required, I may call him. So please, lordship, just, there is only dispute is regarding income, my lord. And they are disputing the income.
Okay, try to call him. Next item.
26.
None has appeared. None has appeared for any party on call. Let this matter be listed in the next week on a date to be fixed by registry.
Mr. Man?
Yes.
Not here. So I have some urgency in this appeal, Lord.
Who is for respondent?
Yes, I said a Lombardo General Insurance Company. Somebody was appearing in such custom.
We'll give a short date. Heard Mr. P. Sharma. Mr. Saika is there.
It is so difficult.
How much time it will take?
My lead claim is also issue
You're ready?
ready, but shorted possibility is not that complete.
Due to paucity of heard Mr. P. Sharma, learned counsel for the appellant. Also heard Mr. A. J. Saika, learned counsel for respondent number 1. Stop. Due to paucity of time, this matter could not be taken for hearing. Let this matter be listed after 2 weeks on a date to be fixed by registry.
Kindly give it a
21 July. 21 July.
Item 28.
Yes, Mr.
I thought Mr. Goswami will take some time and I had also kept my free time. And one of the respondent, even I.
Who is for the respondent? 28.
But
It is Sarkar. We'll adjourn it.
but
Heard Mr. R. K. Bhatra, learned counsel for the appellant. None has appeared for respondent. Let this matter be listed after 2 weeks on a date to be fixed by registry.
the small prayer, my lord, my name is not appearing in the process.
Yes, name of Mr. R. K. Bhatra may be reflected in the cause list as the engaged counsel for the appellant henceforth. Yes, Mr. Das. How much time it will take, Miss? 35? 35 nalage mathima.
I'm being 21. 20.
20.
let him find the record. I'm taking a short break for 2 minutes. Mr. Das, we have very little time. Instead of rushing, we'll fix it in next Tuesday or at a fixed time.
Can be possible to
Except 26th or 29th.
When?
Except 26th and 29th.
can be possible to just let him start and keep this matter as a part of the.
No use in keeping matters part. What is the contention?
The insurance company is disputing the amount that the learner commissioner has awarded the computing the that salary as 12,000. 12,000 per month.
Yes.
And that's
There's, hold on,
Yes, Mr. Das.
the reason for the, I'm disputing the wages, I'm saying it's a perverse finding, 12,000 per month. I had also said at that time, under erroneous impression that this is against statutory ceiling, but there is judgment of the Honorable Supreme Court, which is that ceiling has that deemed maximum ceiling that has gone in 2010 itself. Even after that amendment, there is no upper cap under the WC Act. If someone says he can prove it as 20,000, he will get it. Earlier there used to be a cap, 2,000, it was 1,000, raised to 2,000, then 4,000. After that, in 2010, when wages was raised, no one knows why that PA is there, but there is an interpretation that is as per actual wages or the amount proved.
Okay.
Whichever is. But that deeming provision was omitted in 2010 amendment itself. There is no deeming provision. But so here in this case, there is only one evidence in the entire PLO. Rest the lordship, one is the evidence by the claimant and another person, uncle, that they have admitted in their evidence that they do not know what is written in the affidavit. The only thing that remains is that what is said in the cross, oral. Because they do not know, they very clearly say, both the witnesses have said, we do not know what is written in the affidavit. So what remains of the FAA is that cross-examination part of it. And the owner of the vehicle just gave a written statement and then did not appear. So the learned tribunal in Honorable Commissioner Lordship ought to have given weightage to the statement made by the mother of the claim, deceased.
What she said?
I'll read out that particular part. What the others.
No, what happened? What are the facts?
The mother said, Lordship, I'll just read out one just paragraph, Lordship. I do not know what is written in my affidavit. Kabir Ali was my son. He was died on accident. My son earned rupees 7,700 to 800 per trip. He used to go nearby the place. He used to go 4 to 5 trips in a month. That's it. After that, there's no other. So even if we take both the statements on the higher side, he used to earn my son 700 to 800 per trip. I take it as 800 the higher side. He used to go 4 to 5 times, take it on the higher side. 5 into 8 makes it 4,000. There is no other evidence except this. That's a written statement. The owner did not come and depose. what is written in the affidavit, they clearly, both the witnesses have said, we do not know, I do not know what is written in my affidavit. So that cannot be a guiding here, so what is written in the, or what the owner says in the written statement, unless he comes and proves it. That's the only thing, and also there's judgment of the Supreme Court, I'll give the judgment also, that
Give.
K. Sivaraman versus P. Satish Kumar.
What it says.
I'll just come to the particular. Para 26. It discussed the amended provisions, Lordship. Para 26, prior to Act 45 of 2009, by virtue of the deeming provision in explanation to section 4, the monthly wages of an employee were kept at rupees 4,000. Even where an employee was able to prove the monthly wages in excess of 4,000, it is to be considered as 4,000.
Okay.
That was a deeming cap. The legislature, in its wisdom and keeping in mind the purpose of 1923 Act as a social welfare legislation, did not enhance the quantum in the deeming provision, but deleted it altogether. That doesn't exist now. The amendment is in furtherance of the salient purpose which underlies the 1923 Act of providing to all employees compensation for accidents which occur in the course of and arising out of employment. The objective of amendment is to remove a deeming cap on the monthly income of an employee and extend to them compensation on the basis of actual monthly wages drawn by them. If it is more than 15,000, you would have got that. Now the position is like this. They have to prove it, not any statement made by someone. With so much of liberty being given, there is obviously the need for evidence comes there.
What is the substantial question of law which was formulated?
On the ground of perversity, Lordship. That this is not based on evidence.
Without framing substantial question.
It is always there in the court. Has sometimes the court may not read, but it's there in part of my memo.
Where it is?
Page 5.
Mainly on the ground of perversity.
Yes, perversity. If perversity gives rise to a substantial question.
So your main contention is that assessment of wages was without any evidence on record or contrary to the evidence on record. Okay. Yes, what is your submission?
First of all, so far as the admission of the appeal is concerned, because there is no any substantial question of law.
Okay. It still can be formulated.
Fine. Now, my lord, so far as the salary is concerned, my lord, that the employer has, my lord, employer has issued a certificate of salary paid certificate, which has been exhibited before the my lord, learned commissioner, and this by way of filing an affidavit, the employer, respondent number 1, opposite party number 1, he has admitted that he is paying salary rupees 12,000 per month, along with 150 rupees bhatta. So, it is an admitted fact. As per the section 58 of this evidence.
No, just a minute. Employer was examined as a witness.
My lord, they had not disputed his their duty.
When he filed affidavit.
My lord, before the time limit, he has filed affidavit, my lord.
In
Affidavit, he has, the employer has filed an affidavit and this, and one of the relatives of the deceased has, the claimant, the deceased has filed an affidavit wherein he has exhibited the salary certificate. Salary certificate is there. That has been exhibited. Exhibit 29. Certificate copy আছে record of payment.
Where will we find that exhibit? Where is that exhibit?
That may be in record number.
Ramesh. Give it to him. Give it to him. Flag it.
I have earlier also I have done for the record because they have below. And I have the certified copies. This is
No affidavit, only a certificate. No. Affidavit good.
exhibit 29.
He couldn't.
Appointment.
Sellotape managing.
This is a salary certificate, my lord. Jillul Haq is the employer. He has issued this and one of the relatives has exhibit that. And the Jillul Haq has submitted his affidavit. In affidavit, he has admitted that the affidavit was also in the record. In his affidavit, the employer, opposite party, has admitted that he is paying 12,000 salary.
Where is that affidavit? Ramesh, ইফালে আও। ইফালে আও। এইটো ক'ৰ পৰা ওলাইছে? কোনটো পেজত আছে? Sellotape মাৰি ঠিক আছে। We will take it up some, we'll keep it parted. You
My lord,
come
my lord,
prepared.
My lord, my lord, my lord. Highly oppressed, my lord.
Because we gave you opportunity, but
My lord, my
you
lord.
are not prepared.
Yeah.
Ah.
Affidavit.
No, affidavit is there. In his WS, in his written statement, the employer admitted, my lord, that he is paying 12,000 salary.
Heard Mr. R. Goswami, learned counsel for the appellant, also heard Mr. P.K. Das, learned counsel for the respondent. The hearing could not be concluded due to paucity of time. Release this matter after 2 weeks
It, as per your lord's convenience.
on
Earlier also 12/6 was given.
12 June.
The previous order.
On 12 June.
Binding item 21.
Remaining matters may have to be, we have paucity of time. 21 key matter. What is the issue?
Sir, the appeal against the workman's compensation award, my lord. But they have challenged the award on the ground, my lord, that the policy was not valid. And my lord, whether the substantial question law that has been framed is whether in the absence of the policy, whether the company can be said with the liability of that. That's because their claim is that the accident took place before the policy started.
What is your contention?
Our contention, my lord, is basically that in the document which was not brought on record initially, and my lord, they made some statements in their written cross-examination also, my lord. But they have not been able to disprove the thing. 154, yes. The 154 form also with the policy number, etc. are all there. Those are not disproved.
No, but apparently policy mentions about a date.
Policy mentions a date, my lord, but then, my lord, there
Whether that date is
Yes, sir.
before the accident or
what we may not relied on, that was a policy which may not is prior to the date of accident. But they say that this is a forced policy or something like that. They say that this is not genuine policy. That's what they will continue.
okay. We'll take it up on some other day. Heard Mr. T. Kolita. Also heard Mr. M. Dutta, learned senior counsel assisted by Mr. M. Islam. This matter could not be taken up for due to paucity of time. Let this matter be listed after 3 weeks on a date to be fixed by registry.
My lord, I have a prayer, my lord, because there is a IA, my lord. Stay may be extended, but honestly, my lord, this extension was not prayed for on the previous occasions, my lord. That may be extended, my lord, because stay initially was granted, my lord.
Yes.
And, since it was not granted, my lord, it's not been extended, my lord. And now the matter is fixed for hearing, my lord. One is pressing for that, this stage, my lord.
No.
That it would.
After 22, there was no order.
In fact, in the IA, my lord, there is no.
But they have
There
not.
is a separate IA for stay, my lord.
Yes, in IA after 22, there is none. We will give a fixed date and try to take up the matter
Yes.
on 27th July.
Well,
27th.
Can it be before
For vacation, my lord, if possible, my lord.
Before vacation. Before vacation. House full is, our house is full.
27.
22 July.
Declare that, Your Lordship.